on Thursday, Williams presiding, speaks solemnly with thumbs about the gift on the son. Where?
Thank you very much. See. Yeah, but I don't have any. How did it go? Okay, please. Commonwealth versus Spencer Altman. Spencer Altman.
Yes, sir.
Your Honor, my instructions on this.
Wait, let me get him up here first. Commonwealth versus Spencer Altman. Are you Spencer Altman?
Spencer Althouse.
Althouse, I see that. Pardon me. Were you born in 1989?
Yes.
Last four digits, social security number 8324.
Yes.
We're here. We're here on the pretrial conference, 25 CR 00100 and arraignment and 25 CR 00112. You have a right to remain silent during arraignment. You represent the counsel. The grand jury of Clinton County returned an indictment charging you with wanton endangerment in the first degree, rape in the first degree, sexual abuse in the first degree, and terroristic threatening third degree. Mr. Bailiff, you hear that? Counselor, do you acknowledge the identity of your client receiving that away formal reading and arraignment and pleading not guilty, reserving all pretrial motions?
Yes, Your Honor.
So what's the Commonwealth have to say?
Your Honor, on the other case, we need another negotiation day.
What is the negotiation day?
I'm not sure.
Next month.
I wasn't, I set it with them because it'll be some.
What is the negotiation day next month?
January 5th.
January 5th. Okay, January 5th for negotiation, and the next court date is January the 8th. Both of them are conditions of any bond if you make it, okay? Thank you very much. Tyler Eminette. Will you folks back there kind of scoot together so these folks can get a seat? If you're all scoot together, y'all move on over there, if you will, into the next row so they can get to them easily. Would be good. That'd be good. Thank y'all very much. Are you Tyler Eminette?
Yes, sir.
Good morning. Were you born in 1991?
Yes, sir.
Last four digits, social security number 7104.
Yes.
We're on 25 CR 0038 for a pretrial conference. What do we have?
We have a misdemeanor plea, Your Honor.
Motion's been tendered, sir, that says you wish to enter a plea deal. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
This plea freely and voluntarily given.
Yes.
Are you the same person we just identified in 25 CR 0038?
Yes.
Is your judgment impaired today in any way?
Now, say, I didn't understand that.
Is your judgment impaired today in any way? Do you know what's going on?
Yes, yes, sir.
Yes. Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. I'm gonna go over those rights and I'm gonna ask you to understand, okay? You're all right to not testify against yourself. No one can make the anything, right to speak trial of jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges, since you understand that by entering a plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea, proceed to trial. You understand that? You'll step to your left a little bit. Mr. Hunley, will you step behind him? What is the Commonwealth's recommendation?
Upon plea of guilty to possession of drug paraphernalia, the defendant shall receive a sentence of 12 months probated for 2 years with the probation supervised. The defendant shall be referred to a social service clinician and shall follow the instructions and recommendation of the clinician. The defendant shall receive credit for time served, and he shall gain gainful employment or do a minimum of 30 hours a week community service until such employment is obtained. Any and all evidence in this case be destroyed in accordance with the laws of the Commonwealth.
Is that what you agreed to, sir?
Yes, sir.
You are pleading guilty because you did commit the acts charged in the indictment as amended down, correct? No, your constitutional rights explained to us is still your desire to give up those rights, enter a plea and allow the court to fix your punishment. Okay, okay, is that your signature on the document?
Yes.
Accept the plea, what's the court cost? $155, do you need some time to pay that?
Yes, I will.
Okay, you pay $30 a month, first payment, starting 30 days from day, and of course, $30 a month, you have it paid in full, okay?
Okay, I'm gonna be incarcerated in Dare County for a little bit, so, I don't know if the 30 days on that will work or not, like
Well,
after
let's
today.
say 30 days after your
These-
last incarceration, okay? Okay,
Thank
you, yeah, yeah. Is he gonna still be in custody for Adair County? Are they holding him for Adair County or we just released him?
He is in custody with the Dare County.
So legit to the jail. Make sure they got a hold on him, okay? Okay, thank you. Isaac Dalton. Commonwealth versus Isaac Dalton. 25 CR 00105. Are you Isaac Dalton?
Yes, sir.
Good morning. Were you born in 1988, sir? Scoot over that. There you go. Last 4 digits, your social security number 3833.
Yes.
We're here for a pretrial conference. What do we have?
We've got a plea.
Yes.
It's a felony
It's
plea?
felony plea.
Okay. A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
The same person that we just identified in 25 CR 00105.
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
You, the evidence the Commonwealth has against you, believe you're fully informed about your case. You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. I'm gonna go over those rights, sir, and I'm gonna ask you to understand them, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to give evidence. Your right to call witnesses in your favor, right to appeal this matter to higher court if you lose, your right to private the Commonwealth to prove beyond reasonable doubt to be guilty of the charge. You understand it by entering a plea that you give up those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will review a pre-sentence investigation report under probation and parole. In the event that I do not accept the Commonwealth recommendation and decide to impose a harsher penalty, you have the right to withdraw your plea, go to trial. Do you understand that?
Yes, sir.
You step to the left just a little bit, please, sir. Mr. Judd, what is the Commonwealth's recommendation?
Your Honor, the Commonwealth recommends dismissal without prejudice of the following charges: assault, 4th degree, menacing, resisting arrest, disorderly conduct, alcohol intoxication, and persistent felony offenders, 2nd degree. Following a plea of guilty to strangulation, the defendant shall receive a sentence of 5 years, 5 years to serve. The sentence is run consecutively with the Cumberland Circuit Court case 21 CR 0034. That's it.
Is that your understanding, sir? Is that your understanding? Okay, are you pleading guilty to the acts, to these charges because you did commit the acts charged in the indictment as amended down? Okay, you do so of your own free will?
Yes.
Now, your constitutional rights have explained, is it still your desire to give up those rights, enter a plea of guilty and allow the court to fix your case? You understand after any of this guilty plea, you have other felony convictions, this could be added to them as far as enhancing penalties if you have any future penalties, which hopefully you won't have. That's your signature on there?
Yeah.
Okay, I'll accept the plea order precinct's investigation report and have you back to you for sentencing on January the eighth. Probation and parole will give you a packet to fill out. Okay, thank you. Gary Flannery, Commonwealth versus Gary Flannery. Commonwealth versus Gary Flannery. 25 CR 76. Are you Gary Flannery? You born in 1978. Last four digits for social security number 544.
Yes, thank you.
We're on a pretrial conference where we have
We need another negotiation day.
negotiation day on January fifth. The next court date is on January eighth, both on the conditions you provide.
Thank you, Your Honor.
Dawson Jarvis. Commonwealth versus Dawson Jarvis. 25 CR 009, 25 CR 0016. Motion for short probation, represented by Mr. Poindexter. You are Dr. Dawson Jarvis,
Yes, sir.
born in 2001.
Yeah.
Last four digits, social security number 7215. Okay, what do you have, Mr. Poindexter?
Your Honor, Mr. Jarvis was convicted back in April of this year, this year, for possession of a controlled substance. He received a 5-year sentence, pretrial diverted for 5 years, as long as he went through the Clinton County Specialty Court. He violated specialty court agreement. He was terminated in August. An order avoiding pretrial diversion was entered in September. He was sentenced in October. As of today's date, he served 150 days since his arrest, July 7th. What we're asking
How much
is,
did he serve after he was kicked out of the drug court?
he was arrested July 7th on the violation of the specialty court agreement.
And he stayed in there from July 7th continuously?
Yes, sir.
Today.
Yes, sir.
It's a 3-year sentence?
This says 5 years, but I believe it should be 3 years for possession of controlled substance. I may have just
What
read
does
it
the
down.
Commonwealth have to say?
The documents I have say 5 years.
On possession?
He has another charge, I think, too.
Let's see what else it is.
He has 2 counts of possession, Judge, for 2.5 months, or 2 years and 6 months each for a total of 5 years.
Okay. And so, Your Honor, his family's been in contact with the
What does
Spark.
the Commonwealth have to say?
According to the notes provided to me, he's got about 3 years and 2 months left on the sentence that we just discussed. He has a parole board meeting on February 2026. I think Mr. Stockton had agreed on this case that he would entertain a motion for shop after the first of the year. But apparently went ahead and wrote it in.
And if I could explain, Your Honor, the family's been in contact with Spark Recovery, and they have provided a bed letter to the court where he would be admitted to a 6-month inpatient program. They would take care of the transportation, and they would report back to the court on a bi-weekly basis. We've also attached an exhibit to our motion, a letter signed by Ashley Logan, nurse practitioner, where his father, Danny Jarvis, is waiting a kidney transplant. Mr. Jarvis is a match so far, and so he's wanting to donate the kidney to his father, but it's his understanding, their understanding, that he has to be out of jail to go through the process of making sure that he's a match. So that's why they're asking for it at this point, Your Honor.
Mr. Stockton is under the understanding that whatever medical procedures are required to determine whether he's a match can be done while he's in custody.
Okay, here's what I'm gonna do. Where are you presently located?
Wayne County.
Wayne County. Hey, if we get into the thing and you can present a schedule, I'll make sure that until January the 8th,
Yes, sir.
that's provided. If it comes about that the jail refuses or can't do that, then I'll take a look. I won't do anything to interfere with your donation of the kidney because I know that's time sensitive. And then we'll take a look at this on January. I don't see a reason now. The Commonwealth will need to come up with some compelling reason, I guess, in January for me, not shocking. Just on a probation thing, but right now, I'm going blind. I don't know what kind of other record he has or anything right there. What does he have besides them? These are the two pleas he has, but what kind of record does he have?
I think it sounds better. I'm not sure.
There should be a PSI in the file, Your Honor. I didn't represent him in the underlying.
I don't have, there's not a pre-sentence, though we don't keep PSIs in the file.
Details, if you had prior felony arrest.
No, not found. Had a plenty of invasion, but I think they handed it down.
Well, we'll take a look in January. The Commonwealth will give a recommendation. I don't see a reason for not to go ahead and take a look. February is not too long to stay for, you get parole. You'd be better off parole than you would probate, in my opinion, but that's a chance you can take. But we'll take a look at January. Let's take it under advisement on January the 8th. We'll take a look at it. And if you'll communicate Mr. Poindexter, Commonwealth Attorney's Office about any appointments or anything. I think if they're not willing to take him out, I might release him to a reliable family member to transport him.
Yes, sir.
To these things, so there won't be a problem. Okay.
Yes, sir. Okay, thank you, Your Honor.
Okay,
Thank you.
yeah. Chad Jones. Commonwealth versus Chad Jones. Are you Chad Jones? Good morning. Were you born in 1984?
Yes, sir.
The last four digits of your social security are 1898. Yes, on the pre-trial conference, 25 CR 00104. Okay. That's right. No. They need to get out of there.
Y'all come out, you can't go in there and go. Y'all ain't going, you gotta come out.
This is 25 CR 00104 pre-trial conference. What does the Commonwealth have to say?
Have a plea of guilty, Your Honor.
Felony plea?
Yes, sir.
The motion has been tendered that says you wish to enter a plea today, sir. Is that correct?
Yes,
Are
sir.
you currently under the influence of drugs or alcohol?
No, sir.
Is this plea free and voluntarily given?
Yes.
You're the same person that we just identified in 25 CR 00104.
Yes.
Is your judgment impaired today in any way?
No, sir.
We discussed this matter with your attorney and are you fully advised about your case?
Yes, sir.
Reviewed the evidence Commonwealth has against you.
I'm sorry.
Reviewed the evidence
Yes, sir.
Commonwealth has. You have certain rights under the Kentucky and United States Constitution. You do not have to enter a guilty plea today. I'm going to go over those rights and at the end, I'm going to ask if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed trial or jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to fix evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to file a Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I'm in a planning range of central by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will review a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea, proceed to trial. You understand that? If you step to your left there, sir.
Yes, sir.
Yeah, Mr. Judd, what is the Commonwealth's recommendation?
Commonwealth agrees to dismiss menacing and terroristic threatening. Upon a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 5 years probated for 5 years supervised. The defendant shall enter and complete a long-term treatment facility determined by a schedule through DPA and agreed upon by the Commonwealth attorney. The defendant should be transported to the facility by probation and parole. The bed date shall be scheduled after final sentencing. The defendant shall pay restitution in the amount of $613 at the Clinton Circuit Court office. office at a monthly fee of $50 each month, with the first payment being due 30 days after being released from the long-term treatment facility. Restitution is subject to a 5% clerk's fee. The defendant shall receive credit for time served. The defendant should do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in a matter with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, sir.
You're doing so of your own free will,
Yes, sir.
knowing the constitutional rights and explains to your desire to enter the plea of guilty and allow the court to fix your punishment within the range. Is that correct?
Yes, sir.
You understand that this plea, future convictions can be enhanced under persistent felon offender law causes plea. Is that your signature on that?
Yes, sir.
I'll accept the agreement for now. Order precincts investigation report to be done with probation parole scheduled for sentencing on January the 8th.
Thank you, Your Honor.
Mickey Shelton. Mickey Shelton. Commonwealth versus Mickey Shelton, 24 CR 0085. Good morning, Mr. Shelton.
Morning.
You were born in 1970, is that correct?
Yes, sir.
Last four digits, social security number 78,
No,
75, 83, excuse me.
yes, sir.
You're here on a pretrial conference, wasn't Commonwealth case.
I've got some instructions from Mr. Stockton, they're a little confusing. He wants to either get a trial date or set a negotiation date, so apparently they're fairly close, is that correct?
Judge, candidly, we have not had access to him at this point in time, just due to where he was housed in state custody.
Where was he housed?
Eastern Kentucky Correctional Complex.
So that always complicates things.
It hadn't moved. It's been there for a long time.
No, that is true. That is true. Unfortunately, the rules about visitation have gotten stricter.
Is it your fault? No, no. Well, don't assume it. I was gonna say it wasn't your fault. You said it's his fault.
Okay, I know.
Well, it must be your fault.
It might be.
Yeah.
I mean,
So that's not acceptable, really.
Oh.
I mean, this guy's got a right to have access to a lawyer, okay? Now, so you want a negotiation, we'll do one more negotiation since you hadn't had access. But if they deny you access, you call my office,
I will, Judge.
okay? And the Commonwealth won't be opposed to a little ex parte communication, and I'll call.
No, but
Yeah.
Yeah. Okay, well, we'll have a negotiation day on January the 5th and the next court date on January the 8th. Y'all got papers with you, let me sign. You fill that out for me, and I'll sign for you.
What's he proposed? What he said. He said, yeah.
House man, but they left my office a minute ago.
Well, she is not, because she's had surgery.
Have y'all saw the number I can get you out?
Yes, we do. I know we won't. Let you.
Okay, y'all have safe travel home.
Awesome. Just give me a second.
Commonwealth versus Robert Wright. Commonwealth versus Robert Wright. 20 CR 0070, 25 CR 0072. You are Robert Wright.
Yes, Your Honor.
Good morning. Born in 1981.
Yes, Your Honor.
Last 4 digits, social security number 6138.
36.
36, 6136, you're correct. Where's the Commonwealth, move you left just a little bit. What's the Commonwealth have to say?
now this here today on motion to revoke.
And that pretrial conference on 25 CR 0072. Is that correct, counsel?
We need,
Yeah, that's correct,
we
yes.
need, my directions are that We need a trial date.
Do what?
We need a trial
The
date.
negotiation broken down?
If you all
We've had
have,
issues with negotiations. I would like to have one more negotiation day.
What is the charge? What, you can tell me also, you're more familiar with it. The one that we're trying. Could y'all pull a file up, see what the main
It's a
charge?
possession case, constructive possession, Your Honor. He was in.
I don't want into the details. It's a possession case, and what's the one who's been wanting to revoke him on? Is it a possession? What y'all offering?
He was offered a probated sentence and then he would need to go to rehab in lieu of revocation.
You didn't make it up as my sentence was almost was over with.
He was very close to being finished with his probation period.
Well, he's gonna get another probation period, and then he'd still be out on the street, you know.
That. I was.
I don't want you to, you talk to your lawyer. I don't want you to make any kind of mission here.
I would rethink that.
I would rethink if I had a lockdown probation thing, I'd rethink it. So you can do what you want to. I'll let you have another negotiation day. Because Mr. Stockton is not here today.
Let's go ahead and get another negotiation.
You know, it's on January the 5th, and your next court date's on January the 8th. You know, here's the thing about it, though. If, look, we're not gonna do that. If you had entered a plea today and they did a pre-sentence investigation report, you'd be getting out on January the 8th instead of coming back for another day.
He would be going to the long-term.
Well, that's getting out of jail, you know. Okay, we'll see you next month.
Thank you, Your Honor.
Billy Davis Jr. Commonwealth versus Billy Davis Jr. 25 CR 0071. Are you Billy Davis Jr.?
Yes, sir.
Good morning. You born in 1970?
Yes, sir.
Last four digits, social security number 1524.
Yes, sir.
This is 25 CR 0071. I understand that you wish to enter a plea today. Is that
Yeah.
correct? It's gonna be a felony?
It is a felony plea.
Motion's been tendered, says you wish to enter a plea of guilty today. Are you currently on, under the influence of drugs or alcohol?
No, sir.
Is this free and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0071?
Yes, sir.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
You view the evidence the Commonwealth has against you, feel like you're fully informed about your case.
Yes, sir.
I understand that you want to, I want you to understand that you do not have to enter a guilty plea today. You have certain rights of the Kentucky and United States Constitution. I'm gonna go over those rights with you. At the end, you can see if you agree with them, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, but jury right to be represented in counsel to jury trial. Right to confront and cross-examine all witnesses called to testify against you in process issue, compel their attendance. You have a right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to private Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. You understand that by entering a plea today, you give up all those rights. You
Yes,
understand? Okay, I may consider Commonwealth's recommendation, but it may plain range sentence provided by law. I don't have to accept the recommendation prior to accepting any recommendation. I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, you decide to impose a hardship punishment,
Yes, sir.
then I will allow you to withdraw your plea and go to trial, okay?
Yes,
You
sir.
understand that? Step to the left a little bit, sir. Mr. Judge, what is the Commonwealth's recommendation?
Commonwealth agrees to dismiss no expiration registration plates and to dismiss possession of drug paraphernalia. Upon the plea of guilty to failure to maintain insurance, a motor vehicle as required by KRS 304, the defendant should pay $500 fine and costs. Upon the plea of guilty to possession of controlled substance first degree methamphetamine, the defendant shall receive a sentence of 3 years probated for 5 years supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served and shall be released upon final sentencing. The defendant shall obtain gainful employment or do a minimum of 30 hours community service week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in a manner with the laws of the Commonwealth and the holding agents. And I speak with the defense counsel, he's supposed to be dismissed today.
He's supposed to be released today. Yeah, that's what.
Your Honor, there was agreement with Commonwealth that the defendant was supposed to be released today upon signature of this plea.
Yes.
I don't know. I have to do a pre-sentence investigation. Okay, is that the agreement? Come on back over here as well. Is that the agreement as you understood it?
Yes, sir.
Okay, are you pleading guilty because you did commit the acts charged in the indictment
Yes, sir.
as amended? You're doing so of your own free will. Knowing your constitutional rights, I explained to you earlier, is still your desire to go ahead and let the court fix your punishment.
Yes, sir.
You understand that the guilty plea to the felony portions of this could be enhanced any penalties under future felonies. You understand that?
Yes, sir.
Is that your signature on there?
Yes, sir.
What's the total amount of fees? Okay, I'm gonna order a pre-sentence investigation report to be done on you. Come back here for sentencing on January the 8th. And since you're getting out today, I want you to start paying $50 a month toward the $650.
Yes, sir.
Every 30 days. You need to get a packet there. So they can do the pre-sentence investigation for you.
Yes, sir.
So I'll go ahead and release you today, but now, sir, don't let me down.
I won't, sir.
Thank you.
Yeah. Okay, you have anybody else in custody, Mr. Judge? Edward Purdue. Commonwealth versus Edward Purdue, 25 CR 0010. Are you Edward Purdue?
Yes, sir.
Good morning. Your birthday is 1986.
Yes, sir.
That's 4 digits, social security number 5926. You're here for sentencing today. Have you had an opportunity to look at the creek?
I'm supposed to be on 89.
I've already updated the social security number, probation for all.
Is it substantially correct?
It is.
Have you read it?
Yes.
Okay. So your reason that gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree, first offense, methamphetamine, he should receive a sentence of 2 years. Probated for 4 years, supervised, be referred to the social services clinician, follow their recommendations. Shall pay game for him, it'll be 30 hours, 3 credit until he finds gainful. Good process. You need some time to pay that. You need some time to pay the $125. They pay your first payment 30 days from today. Okay, and $30 every day, every month after that. So it's paid in full, okay?
Thank you.
Yes. Do you meet with, hey, sir? Do you meet with probation parole? Sure. April Blevins. Commonwealth versus April Blevins, 25 CR 0011. Come on. Are you April Blevins?
April, Bill Free Blevins, Collins,
What?
Collins, I'm Collins now, April.
Okay. Commonwealth take note of that. We'll amend the indictment. April Blevins Collins. She's recently married.
That's been about 10, 12 years ago.
Well, that's pretty recent.
But
Okay, you're here for the purpose of arraignment. You have the right to decide. The grand jury Clinton County has returned an indictment charging you with operating a motor vehicle under the influence, possession of drug paraphernalia. Additional alcohol containing possession of a alleged drug. Possession or control of substance, methamphetamine, failure to maintain insurance. You acknowledge the identity of your client, receive and indictment, waive formal reading or anything, pleading not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Yeah, I'm signing a reciprocal discovery order here that requires the Commonwealth to provide information to help you prepare for your defense. There you go. You have a negotiation day on January the fifth, and the next court date is on January the eighth. Okay.
Thank you, Your Honor.
Christopher Braswell. Commonwealth versus Christopher Braswell, 25 CR 0088. Christopher Braswell.
Yes, sir.
Good morning. Were you born in 1999?
Yes, sir.
Last four digits, social security number 5737.
Yes, sir.
You're here on a 25 CR 0088 for pre-trial conference. What do we have?
God, the Commonwealth needs, another negotiation day. on this.
Negotiation day will be on January the fifth. Next court day is on January the eighth. Both of them are conditions you bond. Shara Brown. Commonwealth versus Shara Brown, 25 CR 0087. Are you Charlotte Brown?
Yes.
You born in 1984, last four digits, social security number 0164. We're here for a pretrial conference. What's Commonwealth need?
We need a new negotiation date, Your Honor.
What's going on?
This is a special circumstance, Your Honor.
Yeah, okay, well. Let's do it. Negotiation day on January fifth, next court day on January the eighth, okay?
Thank you.
Brett Carter.
Agreed order continuing the case of January.
Is there a negotiation date?
It wasn't, that was not included.
We're still waiting on a report from KSB, so we can't negotiate.
January the eighth, I agreed order. Danny Clark. I want to Danny Clark, 25 CR 00102. Are you Danny Clark?
Yes, sir.
You born in 1974?
Yeah.
Last four digits, social security number 8651.
Yes.
Good morning. You're there on a pre-trial conference.
It's a pretrial version, plate.
Motion been tendered, says you wish to enter a guilty plea today, is that correct? Are you currently having insurance, drugs, or alcohol? Just plea freely and voluntarily given?
Yes.
Okay. You're the same person that we just identified in 25 CR 00101, is that correct?
Yes.
Is your judgment impaired, Kelly? Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth had against you and you believe you're fully informed about your case?
Yes.
You understand that you don't have to plead guilty to that. You have certain rights under Kentucky United States Constitution for except family. Don't you understand those rights? I'm gonna go over $10. You're right not to testify against yourself. No one can make you say anything. Your right to speak, trial, jury, right to be heard, no counsel, jury trial. Right, in front of cross them, all witnesses called to testify against you. You have a right to issue process, attendance to your witnesses that you call. You have the right to produce the evidence. And a right to appeal this matter to higher court if you lose. You understand that the Commonwealth has to prove your guilt beyond a reasonable doubt. You understand that? Now, by entering it, by entering a plea, then you give up all those rights. Now, make consider comments, recommendations, and every time you make sense to by the law, and make yourself a recommendation. In the event that I do not accept the recommendation and decide to, it's more strenuous sentence, you have a right to withdraw for the trial. You understand that? Let me ask you some qualifying questions. Have you been convicted? Have you been diverted in a case within the last 5 years?
No.
You know, felon convictions that in the past 2 years.
No.
Do you understand if you fully complete the diversion program, charges will be dismissed, be tried and diverted? Do you understand that if you do not complete the diversion program, you'll be brought back before the court and the court will schedule a sentencing hearing? Do you know that?
Yes.
What is the Commonwealth's, move a little bit to the left, sir. What is the Commonwealth's recommendations?
To dismiss possession of drug paraphernalia, found plea of guilty to possession of a controlled substance, first degree, first offense methamphetamine. The defendant shall receive a sentence of 3 years, pretrial diverted for 5 years supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served. The defendant should do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in above case disposed of in a manner with the laws of the state of Kentucky and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yeah.
You plead guilty because you did commit tax charges in the indictment, is that right?
Yeah.
You have to, it's a voice activated microphone.
Oh, yes, yes.
You know, I mean, you have to shake your head pretty hard.
Yeah.
You didn't serve your own free will?
Yes.
You know, your constitutional rights to still your desire to proceed, and with this plea, allow the court to fix your punishment.
Yes.
And you know, if you violate, you're brought back in,
Yes.
then you'll have a police investigation where you get convicted felon, that can be dismissed.
Yes.
Is that your seizure on the motion?
Yes.
I'll agree to accept that, sir. You need the probation parole officer, they give him certain information. Okay.
Thank you.
Shirley can answer. Agreed order to continue the case. Erica Decker.
Wait, Judge, which case?
No, sure.
Shirley can answer.
Okay. That's very. I believe that should be here, to get a date for a suppression hearing, Mr. Crouch, today.
We continued it yesterday.
Oh, we did? Glad we did. Thank you.
Yesterday was a very agreeable day. Erica, nobody agreed on anything for you yesterday. You have an attorney? What? You gotta say something. Yes, no, maybe, next
No, I
week.
don't. I need a
Why
court
is it
appointed
you
one.
don't have an attorney here?
I can't afford one.
Okay, will you fill out the form? Go with her. So I'll be back up there. Amy Elliott. Amy Elliott. Are you Amy Elliott? Yes. I'm morning. This is 25 CR 00102. Miss Elliott, were you born in 1974?
Yes,
Last 4 digits, social security number is 4733. Is that right?
yes, yes.
You're here today for a pre-trial conference. What is the top of this?
The Commonwealth agrees to dismiss possession of drug paraphernalia, place A district.
Is this a miss? This
It's a felony.
Well,
Okay, well, let me do that. Let me do it first.
okay.
And I'll call it, Mr. Chair. You move over, ma'am, you move behind the microphone. A motion's been tendered and says you wish to enter a plea today. Is that correct?
Yes,
Are you currently under the influence of drugs or alcohol?
no,
Plea freely and voluntarily given? Is plea freely and voluntarily given?
yes,
Are you the same person that we just identified in 25 CR 0010? Excuse me. 25 CR 0010, the correct number?
Yes. Yeah, you're 102.
That you?
yes,
Okay, you understand that you don't have to enter your certain rights of the United States Constitution. One of those rights to be represented by counsel. Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes,
You have the right not to testify against yourself. No one can make you say anything right for a speeding trial by jury, right? You're represented by counsel at your jury trial, with right to in front of a crossing and all witnesses called to testify against you. There's evidence, right to call witnesses in favor. Right to fill this matter, how important you believe you're not part of the Commonwealth, prove the other reason without charge, guilt and understand. But entering the plea that you give up all those rights.
yes,
I understand there's gonna be a, is this a diversion? So
It's a felony plea.
it's the felony, yeah. Okay, prior to accepting, the, implementing the agreement, I will order a pre-sentence investigation for it to be done by probation and parole. After seeing that, if I don't, I determine to give you a more serious punishment and reject Commonwealth's recommendation, you have a right to withdraw your plea.
yes,
Okay. Now, Mr. Judd, hit it there. Thank you.
Commonwealth agrees to dismiss the possession of drug paraphernalia. Upon the plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years probated for 5 years supervised. The defendant shall enter and complete a long-term treatment facility determined by and scheduled through DPA and agreed upon by the Commonwealth Attorney. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service work until gainful employment is obtained. The defendant agrees to have any and all evidence in the above case disposed of in a manner with the laws of the state of Kentucky and the holding agencies.
Would you agree to, ma'am?
yes,
Are you doing so because you did commit the acts charged in the indictment as amended?
yes,
You're making this plea of your own free will.
yes,
Okay, now knowing your constitutional rights, I've explained to us, it's still your desire to give up those rights, enter pleading guilty and allow a 45th conviction.
yes,
Okay, you understand that entering this plea, any future convictions, felonies could be enhanced or persistent.
Yes.
That's your signature on the docket there.
yes,
Well, I'll accept the agreement order pre-sentence investigation for it. We then by probation, parole, and schedule sentencing for January the 8th. You shall remain free on your same bond.
thank you.
Yeah. Commonwealth versus Kimberly Elmore. Commonwealth versus Kimberly Elmore, 25 CR 0073. Are you Kimberly Elmore?
Yes,
Good morning.
sir.
What's your year of birth?
3/21/88,
Last 4 digits, social security number.
1247.
You're here for a pre-trial conference, what's the Commonwealth have to say? What's the Commonwealth have to say?
All right, I know there's been considerable negotiations apparently with Mr. Poindexter. My instructions are that the Commonwealth has made an offer, needed a trial date.
That's correct, Your Honor.
What's the charge?
It is, well, there's numerous charges, Your Honor. Let me bring up the indictment real quick.
What do they offer you at this point?
Your Honor, the last offer was 180 days jail and long-term rehab or drug court. And my client wants to proceed with trial at this point, I believe.
Oh, I don't. Oh, I just want to go to rehab.
Okay, so she tells me now that she wants to go to rehab, so maybe we need another negotiation day.
That would be satisfactory, Your Honor.
Well, you saved yourself 180 days there. Good move. You don't need Mr. Poindexter. Mr. Poindexter,
Just a
did a
figurehead.
good job for you here, so I will, I'll go ahead and go through this felony prison situation.
know.
You have your documents ready? She says she's working in her plea. Well, can y'all do the paperwork today?
Maybe I can.
Okay, that's fine. Just have a seat and we'll be back to you.
Yes. Dusty Glad. I'm up versus Dusty Glad. Now, this is Mr. Cross's case.
I'm sorry.
Dusty Glad.
Yes, I'm sorry.
Are you Dusty Gladwell?
Yes, sir.
Born in 1989.
Yes, sir.
Social Security number 4526. Yes, sir. You're here on 25 CR 075 motion to suppress. What is your motion?
Your Honor, we've got a motion regarding the search.
Get behind the
I'm sorry. Motion regarding there was a search warrant, and Mr. Stockton and I discussed about just getting a date.
We're here today.
Well,
You have your-
he's
you have
not
your-
here and
You have your witnesses here? On
Not
motion to
today.
suppress. Okay, well, let's set it for January the 8th.
Okay. Will that be in the morning, Your Honor, or the afternoon?
During the criminal docket.
Okay, that'll be fine. Thank you.
Amanda Gowen says active warrant. Y'all found her now? Not NCIC? Somebody in the Commonwealth?
I don't do that.
But she's not here, so NCIC, okay? Melissa Gross. Commonwealth versus Melissa Gross. Are you Melissa Gross?
Yes, sir.
Okay, good morning. You're here on
Good
25 CR 079. Ms. Gross was born in 1967.
Yes, sir.
Last four digits, social security number 2738. You're on
Yes.
pre-trial conference. What's the comment there say? Oh.
That you agree on all your chief.
Your Honor, just talked to the defense attorney and I'll let him speak himself.
Yeah, Ms. Gross has had some medical issues, Your Honor. We just asked that she be given to the aide tender to offer.
She did what?
Having some medical issues, Your
No, I
Honor,
know, but what do you want?
that we get the date on the 8th for to tender an offer.
This is not going well today. I mean, have you not met with his clients?
I have one. Some of these, we did have an issue during negotiation day with the docket where a lot of the people that were out of custody didn't realize they needed to be here.
Yeah, I want a negotiation date for her on January 5th. I'm not gonna wait to the 8th. She'll come back here on the 8th. She either enter a plea that day, she doesn't have to enter. We'll set a trial. Okay?
Thank you, Your Honor.
Jana Nichols. Jana Nichols, Elmo versus Jana Nichols, 25 CR 092. Are you Jana Nichols?
Yes.
Good morning.
Well,
You were born in 1987.
yes, sir.
Last four digits, social security number 2949. You're here on 25 CR 0092 for sentence. You read the pre-sentence investigation report, number of probation parole.
Yes, sir.
It's substantially correct.
Yes.
Counsel, is there any reason how this lady should not be sentenced?
No, Your Honor.
Following a plea of guilty, possession of controlled substance, first degree, first offense, methamphetamine, she shall receive a sentence of 3 years from plea of guilty to possession of controlled substance, first degree. First offense unspecified, 3 years, 2 3-year sentence for running her for a total of 3 years, probated to 5 years, then she'll receive credit for 43 days served, shall gain for employment. 30 or $30 a week.
We go to this one.
What are the court costs? It costs $155, we need some time for $155.
Just a little bit, yeah.
But I give you a lie, say the correct answer is yes.
Yes, sir.
And you start paying $30 a month. See, the reason I do that, Janet, is because there ain't no dig a hole for you, something you can't do. I don't ever want to give a sentence that I can't do. See, $30 a month, you need to beat the probation and I do the parole reported with that. She need to meet with you.
Yes, sir.
Okay. So you go ahead and do that.
Thank you.
Kyle Norris. Commonwealth versus Kyle Norris, 25 CR 00117. Kyle Norris. Yes. Born in 1988, last 4 digits, social security number. 9777. Say, Ray, you need to say something, voice activate.
9777, yeah.
Okay, that's good, thank you. You're there for the purpose of Raymond. You don't seem to have an attorney, did you represent him in this?
I believe I did. I represented you.
Yeah, I'll continue that appointment. Yeah, you can that. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with assault in the 4th degree, wanton danger in the 1st degree, terroristic threat. You're doing better. You understand those charges? Mr. Bailey? You acknowledge the identity of your client, received indictment, away formally, or in the plea not guilty, reserving all pre-trial motion.
Yes, sir.
If you'll be here on January the 5th at 9 a.m. for negotiation date and January the 8th for your next court date. Does the Commonwealth have any objection to continue on the bond?
No, yeah.
Okay, I'm signing a reciprocal discovery order, which requires the Commonwealth to provide you information to get ready. Considering what kind of charges you got there, just be very careful. Somebody starts in trouble where you walk away. Okay. Thank you very much. Thank you. Sid Roberts. Sid Roberts, Commonwealth versus Sid Roberts, 25 CR 0035. Are you Sid Roberts?
Yes, sir.
You born in 1993?
Correct.
Last 4 digits, social security number 0026.
Yes, sir.
You look pretty darn confident, pretty good.
All right, according to this, we need a negotiation.
January 5th at 9 a.m. here and January 8th. This is the last negotiation night. Reach an agreement. You want to, you know, we'll set your trial, okay?
Yep.
We're gonna have to go to Wayne County just for a second. We got 6 more. We got an officer that has a funeral to attend. Wayne County, will you turn your camera on? Okay. Stephanie Prater, are you there, Stephanie? Okay, you get up in that front chair. Come up versus Stephanie Prater, 24 CR 0092. Stephanie, were you born in 1999? If somebody needs to turn the microphone. Wayne County Jail. Thank you. Still not on.
Motion.
Stephanie, were you born in 1999?
Yes, sir.
Last 4 digits, social security number 2280.
Yes, sir.
24 CR 0092, it's pretrial diversion revocation. What's the Commonwealth have to say?
Your Honor, this is a motion to revoke pre-trial diversion.
Okay, well, tell me what the allegations are.
She absconded drug court.
Come up to the microphone, if you would.
My information is Ms. Prater absconded in drug court.
You want to stipulate
We'll
that?
stipulate to that, Your Honor.
Stipulate I will revoke the pretrial diversion in order for pre-sentence investigation board to be brought back here. And she shall next appear in court on January the 8th, okay? Okay, the witnesses can be released.
Thank you, Your Honor.
Thank you. Bryson Cross. Bryson, Carlo versus Bryson Cross. 25 CR 0098. Are you Bryson Cross?
Yes, sir.
Born in 2006.
Yes, sir.
Or legal social security number 2221, is that right?
Yes, sir.
What does the Commonwealth have to say on this? Says it's a pretrial conference. Well, you got,
It's a felony plea.
you're going to plea?
Yes, it's a felony plea, Your Honor.
Mr. Cross, I understand that you filed a motion today to enter a plea, is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol,
No, sir.
and freely and voluntarily given.
Yes, sir.
Are you the same person we just identified in 25 CR 0098?
Yes, sir.
Judgment impaired today in any way?
No, sir.
Discuss these matters with your attorney. Are you satisfied with his advice?
Yes, sir.
The evidence the Commonwealth has against you, believe you're fully informed about your case.
Can you say that one more time?
I said, have you reviewed the evidence that the Commonwealth has against you and you believe you're fully informed about your case?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them and you tell me, okay? After it's over, whether you understand them or not. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. To produce evidence, to call witnesses in your favor. If it doesn't matter to higher court if you lose. Yeah, and to require the Commonwealth to prove on the reasonable doubt that you are guilty of charges against you. You understand that?
Yes, sir.
Now, by entering guilty plea today, you give up all those rights. I may consider Commonwealth's recommendation, but I may apply any range of sentence provided in the law. Prior to accepting a recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose harsher sentence, you have the right to withdraw your plea of guilty and proceed with trial. You understand that?
Yes, sir.
Your Honor,
Yes.
I plea of guilty to indictment number 25 CR 00098 on the charge of theft for unlawful taking of less than $500. The defendant shall receive a sentence of 12 months. And upon a plea of guilty under the indictment set out for the charge of burglary in that indictment, the defendant shall receive a sentence of 5 years. The 12-month sentence and the 5-year sentence shall run concurrently for a total of 5 years. Upon a plea of guilty to indictment number 25 CR 0099 for the charge of possession of a controlled substance in the first degree, namely methamphetamine, the defendant shall receive a sentence of 2.5 years. The 5-year sentence under indictment 25-00098 and the 2.5-year sentence under indictment 25 0099 shall run consecutively for a total of 7.5 years. Probated, however, for 5 years with the probation supervisor. The defendant shall enter and complete a long-term treatment facility for a minimum of 6 months, determined by and scheduled through the Department of Public Advocacy and agreed to by the Commonwealth. Defendant is currently incarcerated and shall remain in custody until finally sentenced and completion and shall completion of serve 60 days in jail.
Is that your understanding, sir, of the recommendation of the Commonwealth?
I'm not sure, Judge.
Well,
Then it shall pay restitution in the amount of $197.21 payable to the Clinton Circuit Court and subject to a 5% clerk's fee. The defendant shall receive credit for the time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week community service. And he agrees that any evidence contained in this case be destroyed in conformity with the laws of the Commonwealth.
is that your understanding of the Commonwealth's recommendation, sir?
Yes, sir.
Are you pleading guilty because you act charged in the indictment as?
Say it one more time.
Are you pleading guilty because you committed the acts charged in the indictment that's amended down? You did what you're pleading guilty to, is that correct?
Yes, sir.
Okay. Are you doing this of your own free will?
Yes, sir.
You understand, knowing your constitutional rights that previously explained to you, is it still your desire to proceed to enter a plea of guilty until our court conviction or punishment is arranged for the law?
Yes, sir.
Understand that if you're entering this guilty plea, any future felony convictions could be enhanced with a persistent felony offender law. You understand that?
Yes, sir.
Where is the plea document right here? Can you hold it right here? Thank you. Is that your signature on there, sir?
Yes, sir.
I'll accept, here you go. I'll accept the plea. And request a pre-sentence investigation report to be done by probation and parole and schedule a sentencing on January the 8th, okay? Now, do we,
Judge,
yes,
I already have, gotten a bed at Spark in Russell County rehab. Is, do I need to have a bed letter sent to you?
wait, your attorney needs to do that with the Commonwealth to prove it. We'll go ahead, but you'll have to be sentenced. Okay, and they'll, in probation and parole, will be over to talk to you about real soon, okay?
Bryson, Officer Morrow will be over to see you this afternoon at the jail.
Okay, no.
Okay, well, that concludes Wayne County. Wayne County, you're excused. If y'all will clear the grand jury area out to the grand jury fixing to come in, please. Go back into the jury room if you want to. Carson. Okay, bring the grand jury, please. All rise for the grand jury, please. Okay, everyone can be seated. There's a four-person grand jury. Will you stand there, please? Will 9 or more of y'all agree to what you have?
Yes.
Mr. Bailiff, you pick that up. Yeah. Thank you. Okay, everything appears to be in order. I'm gonna sign the document that is attached to your return. We'll either have warrants issued or summons. If they're in custody, we might have summons, but if they're not, we'll have warrants. We'll set a bond to secure their attendance, or if they're a danger to anybody, to protect the public. I thank you for your work here today. Next day that you will come back, Lord willing, is, January the 8th. Huh? Oh, I thought y'all volunteered to do another 6 months. Well, there was some talk about that. Mr. Hunley, didn't you hear that they volunteered?
I'd like to have them back.
Yeah, that's probably that. Well, thank you so much for your service. And you know, I don't know whether the clerk's office will get your big check to you by December, but if they do, I would not plan on going very much farther than the dollar store for the shopping trip, which is fine. I shop at the dollar store all the time. I mean, little packages, big price, you know. Thank you for your service. It's extremely important what you've done. Without the grand jury, we couldn't proceed with administering justice in Clinton County. So on behalf of the citizens of Clinton County, I express my gratitude to you for your service. And the good thing about it is, at least in district court, I mean, in circuit or district court, you won't have to serve again for 2 years. They can still call you to the federal court. So I just, well, all rise for the grand jury and your excuse. Let's go to Pulaski County. Roder, you're. Pulaski County, we do a couple. Eddie K. Jarvis, Commonwealth versus Eddie K. Jarvis.
Morning, Your Honor.
Good
morning, Your Honor. Brandon Storm.
Senator Storm is on there and other council here. And this is 25 CR 0064, Commonwealth of Kentucky versus Eddie K. Jarvis. Mr. Jarvis, you born in 1947. Somebody needs to turn that microphone on there in Pulaski County. Pulaski County, turn your microphone on. Thank you. Okay, thank you. Mr. Jarvis, were you born in 1947?
Yes, sir. I'm old enough to be your daddy.
The last 4 digits of your social security number is 7422. Is that correct?
Yes, sir, it is 7422.
Okay. What's the Commonwealth have to say in this case? Yeah, y'all want to move on. Yeah, y'all want to let Mr. Hunley in there? Come on up, Mr. Hunley. What do you have to say in this case?
I may need some enlightenment.
Come on up to the microphone.
Commonwealth has filed a motion for KCPC evaluation.
And we haven't got it yet.
The motion was just filed for today.
Okay. Go ahead.
I apologize. I'll get here as close as I can, Judge, so it'll pick me up. We had scheduled and provided the state with a copy of a report.
Yeah.
I would like to, if the court would be agreeable, submit it to the court for in-camera review and file the report under seal. I spoke with Mr. Stockton. He indicated to me that he would prefer to, before we send him off to Mr. Jarvis off to KCPC, allow the daughter to get temporary guardianship so we can attempt to put him in a memory unit at an appropriate facility. And then at that time, come back next month and see if we can reach a resolution, and I believe we can. The only complicating factor, Judge, is the holidays. That would be the only thing that would keep us from being able to get this thing resolved at that time, I think.
That's consistent with my understanding.
Well, I'm going to go ahead and do an order referring him for evaluation. And of course, you have a right to have your expert there when they evaluate him. So you'll have to go through the schedule. It'll take a while. I'm not inclined to do a release right now, just because why haven't we done it up to this point? You know, I think there's some danger here involved. What, you know anything about this, Mr. Hunley? Or-
I know a little about the case, Your Honor.
Has to go with the daughter, right?
No.
What are you asking again?
What's happened, Judge, is
Just
we,
ask me what you're asking for. Tell me
what
you're
we
asking.
want to do is set it for the negotiation day and give us enough time to get him into a mental unit, at a memory unit for people with dementia, Alzheimer's.
So in other words, if you can get him in a mental unit, the Commonwealth would agree where the mental unit is, and he would go there until the court date.
And we'd assume,
I'll agree to that.
yeah, and we would assume that the
Don't talk your
sheriff,
way out of it.
no, I just want to make sure he's got transportation, Judge.
Well,
I mean, however you want to do that.
yeah, it varies, you know, so
The Commonwealth would be interested in what kind of facility.
that's where they have to agree. They have to agree.
Yeah, you'd have to
They'll
agree.
provide you one, you'll sign off on it. And then his daughter is a responsible person. And
I'm sure she is.
if she's willing to take the responsibility of transporting, that'd be okay with me. Okay, that'll be all right with me. But you ought to have somebody with you. I mean, not impugning anybody or anything happen. It's always good to have a witness. So once you find it, you get a hold of the Commonwealth attorney about the facility.
Yeah. And one other thing, Judge, his daughter had indicated to me that he has a neurological appointment that's coming up, I think, maybe the 11th of this month. And we were hoping that the jail or somebody would transport him to that.
Well, you just give me a transport order, I'll sign a transport order. That would be a transport order by the local jailer or the sheriff. I guess the sheriff transports on those things.
You tell me who and we'll get it done, Judge.
I think probably jail does.
I think the jail would be.
Yeah, okay, give me an order and get it with specificity on there. And then, so here's where we are. Is there gonna be a long-term, the treatment center, as far as memory loss treatment center agreed to by the Commonwealth. Released there with included in the order that's drafted that if he should leave there under any circumstances other than discharge or even under discharge, he'll go back into custody. Okay? Okay.
We are not doing a KCPC order at this time.
Yeah, I'm gonna do KCPC order because there's no danger of him getting a KCPC within a while, so it might as well be there. I'd rather go ahead and withdraw that order and not have it under process. Senator Storm, aren't you gonna contribute anything? We've actually inconvenienced everybody in order to accommodate you there in your plush luxury car and everything, and you're not saying anything?
Well, Your Honor, I didn't want to interject myself until it was appropriate.
Well, everything's pretty well right now. Is there anything you'd like to add?
No, I appreciate your condolences, your convenience of allowing me to do this by Zoom, Judge. I was on my way, left Bardstown this morning and got stuck in some sort of traffic accident.
Okay. Thank you very much.
Thank you, Your Honor.
January the 8th is the next court appearance. Okay, thank y'all very much.
That's all I have.
Thank you. Yeah, Jesse Pittman is next in Pulaski County. Jesse Pittman.
Hi, Jeremy. Your Honor, am I to speak on this?
Yeah, no, Jesse Pittman. We're finished with Mr.
Judge, I'm here, sir. Give me a minute to leave. You saying I'm not? Yeah, they're
Okay. Mr. Jarvis. Mr. Jarvis. We're finished.
Yes,
No, we're finished with Mr. Jarvis. See you later. I want Jesse Pittman. Commonwealth versus Jesse Pittman, 25 CR 0081 and 25 CR 00106. Are you Jesse Pittman?
yes, sir.
Good morning. Were you born in 1986?
Yes, sir.
Last four digits of social security number 5676. Is that correct?
Yes, sir.
You're on
Yes,
the
sir.
pre-trial conference. What do we have?
Judge, we would like a trial date, please.
Is Commonwealth here?
We're,
What is the charge you're gonna try him on, Mr. Huntley, do you know?
Well, it's strangulation, kidnapping, and,
25-106.
25-106.
That's a solid point. One, the nature of first degree, whether it be a person.
Okay, I would suggest sometime in January here. What days y'all have? You have court here on Tuesday, did you? What about on the 13th?
That's the day after the mediation.
I have. Judge, just so the court is aware, in the last 3 days, 3 of our attorneys have had emergency medical leave enacted. Almost in,
That's the reason I'm giving you out. in
Yes, yes.
January.
I'm sure we will rise to the occasion, but it's almost happened in seniority, and by that logic, I'm next. So hopefully I don't get hit by lightning or something when I leave the courtroom today, but my schedule has all of a sudden gotten very complicated.
The Commonwealth, what Jesse's open the last week.
How about, schedules? Just a 1-day trial, you think?
I think so, Judge.
How about, January the 7th?
Judge, that would be just because I am one of the last men standing in my office, quick for me to be prepared on that day. I have court almost all of December because I'm filling in.
You're, fine with me, your client's incarcerated,
I know, Judge, but I also want to give
I
him the
understand.
best
I was
defense
defense lawyer
possible.
for years. I
Yeah.
understand.
I want it to count.
Well, how many months out do you want this?
I don't, January is fine if we could
Well,
just
that's the only day I have in January.
Is it?
So we'll have to go on out then.
If
Let's go out to February.
February.
You don't have anything on the 18th,
The Commonwealth's office will be out that entire week. The winter conference.
Mhm. The 25th of February. On Wednesday,
The last week.
that's great. How about on the 24th? Do what?
Where about?
24th of February?
I can make myself available on that day, Judge.
Well, thank you.
I'm sorry.
Appreciate your being available.
I try.
You said it's 106. 25, the other 106.
Okay. Okay. We'll go next to, Michael Taylor.
Your Honor, is there any way that I could, could you consider a bond reduction so that maybe I could even hire my attorney?
You'll have to talk to your attorney about that. And she can negotiate it with the Commonwealth. I tried to get you a quicker date than this, but
Yeah, I see that, Your Honor. I appreciate it. I thought I was coming for bond reduction hearing today is what I'd asked her, but,
she
they
can,
didn't have.
she can set one. And because Mr. Stockton is not here today, if you want to set a bond reduction in one of the other counties sooner than that before we come back here, I'll consider.
Please, sir, if you don't mind.
No
Thank you,
problem.
Judge.
Yeah. Michael Taylor.
Thank you, Your Honor. Be glad you got this. Come back.
Are you, Michael Taylor?
Yes, Your Honor.
Morning. Were you born in 1984?
Yes, Your Honor.
The last four digits, social security number 2856.
Yes, Your Honor.
We're on 24 CR 0002. Mr. Poindexter's here. Say something, Mr. Poindexter, so he can see you.
Yeah, Michael, can you see me?
There he can now. Okay.
Yes, I can see you.
What do we have in this case here, Commonwealth?
It would appear that we either have or are seeking a competency hearing in January. Is that correct?
Yes, Your Honor. If we can get some dates, so that way we can check with the doctors to see which one works for them. We've got an expert and of course they've got one.
The report already back.
It is, Your Honor.
Okay, well, let's set the hearing on January the 8th.
And then on that date, are we gonna get dates to see if the doctors can make it?
I'm setting it on January 8th.
Okay.
Sitting on January the 8th, and if there's something that comes up and they can't be available, y'all can get with us by agreed order.
Okay.
Okay,
All right. Thank you, Your Honor.
we'd like to be present too.
Yes, sir.
Okay, Pulaski County, thank you. Mr. Taylor,
Your Honor, may I address the court?
your attorney's gonna come up where he can talk to you privately about what happened today, okay?
Well, I just want to see the discovery of my case. It's been 2 years and I have not been allowed to see the discovery in my case.
He's gonna come up and speak to you. When are you gonna be up there?
It'll either be this afternoon or first thing in the morning.
He'll be up either this afternoon, bring the discovery and whatever he has to see you this afternoon or first thing in the morning, okay?
Thank you, sir.
Pulaski County, thank you very much for your cooperation. Y'all are excused. Roeder Correctional Complex. Thank you for your, we're here for sentencing. Roeder Correctional Complex. I guess that's, they on there? Yeah, there they are. Commonwealth versus William Purdue, 25 CR 00090. Are you William Purdue?
Yes, sir.
You born in 1971?
Yes, sir.
Last four digits of your social security number are 7571.
Yes, sir.
Okay, you're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct, sir?
Yes.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon the defendant's guilty plea to possession of controlled substance, first degree methamphetamine, first offense, the defendant shall receive a sentence of 1 year to serve on operating a motor vehicle, alcohol concentration, or being at above 0.08 or under the influence of other substance. He shall pay a fine of $200 in court costs. The 1 year sentence shall run consecutively. Clinton County Indictment 15 CR 003 in Clinton County Indictment number 23 CR 00130. Now, the only question I have about that, are those two cases running concurrently, or now are those two consecutive cases? You see what I'm saying?
Judge, it's my understanding that they were run consecutive together.
Well, I'll have to,
Was the agreement that?
wait just a minute. I'm not talking about the one today. I'm
Yes,
talking about others, so I
He
don't,
was sentenced on the 21 CR 130, and was ordered to run concurrently with 15 CR 3.
okay, 15 CR 003 and 23 CR 00130 are running concurrently. So those two are running at the same time, and then you'll just get 1 year stacked. I didn't make sure I didn't stack you twice. That's what I was trying to do, okay?
yes, sir. Thank you.
How much is total court cost to fine? Well, it's a DUI, so yes, that's correct. $200 fine. Okay, it's $780 fine and court costs together on this thing, and I'll let you start paying it at $50 a month within 30 days when you're released, okay? So you don't have to worry about it. And that'll give you a little chance to get on your feet before you have to start paying it, okay?
Yes, thank you, sir.
Okay, thank you very
Thank you.
much. Now that's all we have at Roder. Roder, you may be excused, and thank you for your cooperation.
Your Honor, can my lawyer contact me up here? I was needing to talk to him. I've been trying to call his office.
Yeah, I'll schedule an appointment.
Well, when can you see him?
It's difficult with that facility. I'll have to,
Well, I mean, give me a time frame. Within the week?
within a week, yes.
Within the week, he'll be contacting you for an appointment, okay?
All right, thank you, sir.
Okay, let's go back then, I guess, to the out of custody docket. Rockcastle County. Sorry, Rockcastle County, if you're on there. And then Russell County, real quick. Rockcastle County, turn your microphone on if you will. Turn the microphone on at Rockcastle County. Commonwealth versus Ashley McCusker. Cusker. Still not on.
Can you hear me?
Can hear you now. Thank you very much.
Okay, all right, we're good.
Thank you. This is 24 CR 0048 motion for shock probation. You want to say that you are Ashley McCusker, is that correct?
Yes.
It's 24 CR 0048. What does the defense have to say?
Yeah, Your Honor, she's been incarcerated since, I believe, May,
On what charge?
April, it was April.
in April.
Yeah, on what charge? Go ahead.
Her probation was revoked, from.
What was the charge?
It was a possession charge.
No, it was a wanted danger.
Wait just a second, ma'am.
Sorry.
You get an opportunity to say something if I call on you, okay?
Sorry.
No problem. What's the Commonwealth have to say?
Mr. Sutton has indicated that he might be agreeable to it if he had details of the plan that she has of where she's gonna stay, what her living arrangements are, what kind of treatment that she's getting. We don't have any of that.
Okay, Mr. McCusker, what Mr. Hunley just said is they're inclined to go along with your shock probation, but you need to get with your attorney and get a plan about where you're gonna live, if you got employment, what kind of treatment, because you already slid off the wagon once real bad, you know?
I know.
Okay.
I know.
That doesn't mean you can't make it. I'm pulling for you, okay? So you get that just as soon as you can. And if they do, you won't have to wait till the next rule day. If it's approved, I'll sign an agreed order to let you out, okay?
Thank you, Your Honor.
I'll call you today.
Make sure you get a good plan where you're gonna live, a solid place and get a job or something, okay?
Thank you. Thank you so much.
Okay, Rockcastle County, thank you for your cooperation. Y'all can be released.
Thank you, Your Honor. Y'all have a good day.
Yeah, you too. Russell County Detention Center. Well, we had one satisfied customer today. Russell County Detention Center.
Yes, sir.
Okay, Winter Brown, is it Winter Brown? Are you Winter Brown?
Yes, sir.
Good morning.
Good morning.
You're on 25 CR 0065. Ms. Brown, were you born in 1961?
Yes, sir.
Last four digits social security number 0964.
Yes, sir.
What does the Commonwealth have to say? You got a plea of some sort, Mr.? Is it a
Yeah,
felony plea?
We do.
Felony plea. Okay, Ms. Brown, I've been informed that you wish to enter a plea today. Is that correct?
That is correct.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Pardon me?
Is this plea freely and voluntarily given? What you did
Yes.
voluntarily? Are you the same person that we just identified a few minutes ago in 25 CR 0065?
Yes.
Is your judgment impaired today in any way?
No, I don't. I've got a low memory.
Have you discussed this charge with your attorney and are satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the United States and Kentucky Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights, okay? You have
Yes.
a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to the higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. Understand that by entering this plea today, you waive those or give up those rights.
Yes.
Yeah, I may consider the Commonwealth's recommendation, but I can apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event after reviewing that, I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. You go to trial. You understand that?
Yes.
Okay, Mr. Judge, what is the Commonwealth's recommendation?
Your Honor, the Commonwealth agrees to dismiss public intoxication, the possession of drug paraphernalia, and possession of controlled substance not in the original container. Upon a plea of guilty to possession of controlled substance, first degree, first offense, 2 counts, the defendant shall receive a sentence of 3 years on each count to run concurrently for a total of 3 years, probated for 5 years supervised. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence in both cases disposed of in accordance with the laws of the Commonwealth of Kentucky and the holding agency.
Is that what your client
Yes,
agreed
sir.
to? Is that what you agreed to, ma'am?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
Doing so of your own free will?
Yes.
On your constitutional rights to explain to us, is it still your desire to give up those rights by entering a plea of guilty to the charges and allow the court to fix your punishment in the range permitted by law?
Yes.
Okay, do you understand that after entering a guilty plea, any future convictions could be enhanced under persistent felony offender law?
Yes.
Okay, can I have that plea agreement? Okay. Is that your signature, ma'am, on the document there?
Yes.
Yeah, I accept the agreement order pre-sentence investigation report to be done by probation and parole and schedule your sentencing on January the 8th, okay?
Thank you.
Thank you. Brandon Hall. I'm up versus Brandon Hall. Little charge. Are you Brandon Hall?
Yes, sir.
Morning.
Morning, sir.
This is 25 CR 0039. Mr. Hall, were you born in 1982?
Yes, sir.
Last four digits of social security, 3773.
Yes, sir.
Motion of shock probation. What do you have for the defense?
Yes, Your Honor. Mr. Hall has been incarcerated since March 29th, 2025, so
On what charge?
it's trafficking charge, Your
Okay.
Honor. He's not parole eligible until November 30th. Mr. Hall's never gone to rehab. He'd like to get out and really work on his addiction. He has 5 children that he wants to support, ages 9 to 25. While he's been incarcerated, he's been participating in Alcoholics Anonymous, and it seems to have had a pretty big help, been a big help to him. Again, he just wants to get out and get into some type of treatment, whether it's rehab or drug court. He has a job lined up with Mr. Stevie Lee if he does get released, and then his mother is willing to let him live with her here in Albany, if possible.
What does the Commonwealth have to say about this? What does the Commonwealth have to say?
Your Honor, is he presently serving a 12-year sentence?
Yes.
Your Honor, the Commonwealth strenuously opposes this. In addition to being on a 12-year sentence, he has 8 prior felony convictions in Clinton and Cumberland County, Kentucky. I just don't believe that he's suitable for shock probation.
And Your Honor, he does have a pretty extensive history.
I'm considering an extensive criminal record. I cannot do a 12-year sentence in the criminal record he has. I cannot grant shock probation. So that can be denied. Thank you very much. Bethany Harding.
Bethany.
Are you Bethany Harding?
Yes, sir.
Good morning.
Morning.
This is 25 CR 0086. Were you born in 1992?
Yes, sir.
Last 4 digits of social security are 0901. We're
Yes,
on a
sir.
Motion to suppress, motion to revoke. Okay, what? You ready for?
Your Honor, we would ask that this be continued to January because she is going to receive new charges.
Probably be indicted today, if not in
And they
January.
have been.
Okay, there are new charges coming, Ms. Harding, so we'll schedule you on January the 8th. And if, I guess we'll know where she is to serve her, so she'll be served by then. We'll arraign her that date. And then do you want a negotiation day? You want her there on the, so you in anticipation?
There's a little bit of limbo, Your Honor. I've not been retained on the new charge yet. We want to look at it and see, and then I'll go meet with Bethany, but Mr. Stockton and I have discussed.
Well, let me put it on January the 5th, and if you're not representing her, you just inform them that you will be there, January 5th and January the 8th.
Thank you.
Yeah, wait. Motion to revoke bond. She's in jail.
Well, your motion was filed.
Yeah.
It's based on new charges.
Do what?
It's based on new charges.
Yeah.
She was on a bond when she was.
Okay, and she's got other charges, so I will revoke the bond and just have her remain there, and we'll consider bond on January 8th. When she
Your Honor,
gets
I understand the court's revoking the existing bond. Would the court consider setting a higher bond with substantial
back. She
restrictions?
hasn't been reviewed, and I don't know anything about what the new charge is gonna be, so when I get what the new charges are, we'll take a look at the bond.
Thank you, Your Honor.
Wesley McGaw. Are you Wesley McGaw?
Yes, sir.
Morning.
Good morning.
This is 25 CR 0083, 94, 95, and 96. You're here for sentencing. Mr. McGaw, were you born in 1988?
Yes, sir.
4 digits social security number 6977.
Yes, sir.
Your sentencing, you get an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Yeah. Is it substantially correct?
Yes, Your Honor.
Is there any reason this young should not be sentenced?
No, Your Honor.
Okay, upon a plea of guilty and indictment, 25 CR 0095, 94, rather, he shall receive a sentence of 5 years. Upon a plea of guilty on 25 CR 0095, he shall receive a plea of 5 years. Upon a plea of guilty and indictment number 25 CR 0096, he shall receive a sentence of 3 years. Plead guilty on 25 CR 0083. He shall receive a sentence of 5 years. These charges above on these 4 that I've just named have some concurrently within each one of the charges. The 5-year sentence is indictment number 25 CR 0094. The 5-year sentence is in 25 CR 0095. The 5-year sentence in 25 CR 83 shall run concurrently for a total of 5 years. This 5-year sentence, 23 0094, 23 CR 0095, and 25 083 shall run consecutively with indictment 25 CR 0083 for a total of 8 years to serve. Now, I think there might be a typo in that last paragraph there because it talks about 5-year sentences in 83 running with an 83. You see what I'm saying there? Last sentence. So, but the cumulative effect is 8 years, so that probably needs to be checked out to see if there's a typo in that second 25 CR 0083. Okay. Thank you very much.
Thank you.
James Shelton. Commonwealth versus James. Are you James Shelton?
Yes, sir.
Okay, this is 25. Good morning. This is 25 CR 0097. Mr. Shelton, were you born in 1963?
Yes.
Last 4 digits, social security number 8382.
Yes, sir.
It's 25 CR 0097 for a pretrial conference. What was it?
Pardon?
I'm waiting to see what the Commonwealth has.
We need a negotiation sector.
Okay, negotiation date in this case for January the 5th, and the next court date's January the 8th. Now, Russell, do we have anybody else over there that we're supposed to have? You got a negotiation day on January the 5th, sir, and the next court date's on the 8th. Your turn, when are you gonna be over to see him?
I'll see him Monday. Should be over there
Your
Monday.
attorney will be over there to discuss the negotiation date with you, and he'll be over there to see you on Monday, explaining things to you, okay?
Okay.
But thank you very much. Russell County, is there anybody else you have there for us?
That's it, sir.
Okay, you may be excused, and thank you for your cooperation. We're gonna have to take a short recess here, about a 5-minute recess. Jeremy Shepherd, it looks like it's active warrant. There's an active warrant. Y'all want NCIC there?
Yeah,
Nathan Stockton.
Your Honor, please.
Commonwealth versus Nathan Stockton, 25 CR 0022 and 25 CR 0036. Are you Nathan Stockton?
Yes,
You born in 1991?
yes,
Last four digits, social security number 5920.
yes, sir.
We're on pretrial conferences on both of those. What does the Commonwealth have to say?
You know, first we need a trial date on this case. Second, I think the court should be informed. I have already given extensive notice on some proposed 404B evidence. I think maybe one more yet to come of very similar incidents.
What kind of instance we're talking about? What is he charged with?
He's charged basically with theft by deception.
2 counts.
Checks or what is it?
It would be fraud and inducement of getting municipalities to pay money and then not getting anything for the service for their money.
Municipal individuals, I mean?
Monticello Fire Department,
Yeah.
the Cumberland County Extension Office,
Yeah.
and
The signs or what were they?
sign, and the sign company out of Somerset.
Okay.
Yeah, we need a trial date, Your Honor.
we previously had this, would benefit.
I've learned a lot.
Just one day, you need some time to disclose the 404B to them and they'll.
Well, I will.
What kind of offers out there?
There are no offers.
You'd make an offer on it?
There was written the restitution, you would take.
There was an initial offer and
Okay, well,
then
let's set a trial date. What about the 14th? January?
Now that week is pretty crowded for us.
That's gonna be.
We don't have a thing in the last week of January.
Well, I don't either, and I mean to kind of keep it that way.
All right.
Are you trying? Is just Jason?
Yeah, I got a meeting.
We have district court here on the 14th. Did we looked at January 14th. That was a crowded meeting. What about the 21st?
It's not a one-day trial. I'm not sure this is a one-day trial.
Okay. Nobody told me that. How about the 20? Let's go out to February. Is it Hamilton versus Harlow? What is that? What is it? What is? Big shot. Okay.
I'm actually concerned, I mentioned for the school concerned about 2 days.
What about the 19th and 20th? January. What is that? I did not have it on my calendar. What about the 26th and 27th? Did we look at that? Yeah, I forget that. Well, let's do it on the 13th of February, and that's on a Friday. And if we don't finish that day, we can come back in on the Monday.
The Commonwealth's office will be out the 16th through the 20th.
Okay? Mm-mm.
Exactly.
About the second week in February, Judge.
Every 2 days.
Carver trial, civil case.
Like a week before. We have to trial Thursday.
On what days?
Yeah, you see.
Yeah.
Or late Sunday night.
Oh, here, Sunday.
One thing. What about March?
Now you get into March, you get into around March, that's gonna be
Well, I don't,
crowded.
after the second, I can't do any trials for the DPA, so we'd have to, he'd have a new attorney.
We'll just set it and then we'll see.
That may be,
That's what we're gonna do.
Let's go back and look at December again.
December,
Oh, wait, I see.
I can't do it.
Well, I'm talking about late December.
No, I can do.
Okay,
Sorry.
when did you say the last day you can try one is?
March 2nd.
Do you still do it on the second?
I'm not entirely
I
sure.
don't want to do it. What's that?
Can we move the?
Motions after that, you know, we had a motion to be trial, stuff like that, gets him at the end of his tenure, so I won't put him out of it.
They said they had civil trials that week, the fifth and the sixth. So Megan will have to prepare that day, and then if we do it, that's. So it's on district court on the third. Yeah, so that does give us 2 days to come. Yeah. Can we move the Cumberland motion day?
No. What did you say about the fifth and sixth of January? Let's go back to January. Can you be ready by the fifth and sixth of January? It's a month from now.
With January fifth is negotiation.
You what?
January fifth is negotiation day, so that.
Well, everybody doesn't have to be there that day. does it?
Jesse and I will try this together.
Okay, another complication here.
Lane, can you be available for the negotiation?
No, that's okay. They gotta do that
That's
too.
Okay, so what about the fifth, or the sixth and the seventh? I have district court on the sixth.
Here's what happened. 30 days.
Let's go to sixth and seventh then.
Okay. January.
6th.
January sixth and seventh.
When do you want to hear the board of LD?
Wait a second. Stockton.
I don't know, depending on how the 404B goes, we might be able to set up a resolution.
Oh, he's not paying for the restitution.
And he wants to pay, it's just.
Well, the restitution was just entered in.
Okay.
My problem, Judge, on what they're saying is there's been no,
Okay, I won't do it then. Let's just continue it generally.
it's
You know,
just
I mean,
been-
because I looked at January, February, we can't do March, we'll do it in April. You know,
we can, but.
yeah. But we have to have a new attorney, that'll put it off another 6
No,
months.
that's okay, we can cover it.
Well, wait just a second. Y'all can't do it the 12th through the 16th. Correct?
No, January. That's.
What about January?
We have mediation with Mr. New on the 12th. We have Monroe motion day on the 15th. And we can.
Would the 20th and 21st be better than the 6th and 7th for you guys?
Yeah, we can do that.
Now that gives you the January 8th to have the 404 meeting. Y'all need to schedule for January the 8th. You have any 404 meeting questions? That probably works out better anyway, because that gets us ruled out there to deal with those issues. Okay,
All right.
Thank you.
Sean Stockton.
This is, it's on there, all in there, it's, I don't should be this.
David Sullivan. David Sullivan. Keep your hands out of your pockets, you know. Well, yeah. Count, what?
I hate to get a cough off right now. Yeah, sorry.
Commonwealth versus Sean Stockton, 25 CR. Excuse me, David Sullivan. Let's get going. Sure, inside. Commonwealth versus David Sullivan, 23 CR 0044. Were you born in 1980?
Yep.
Last four digits, social security number 6949. Your date for sentencing, have you had an opportunity to go over the pre-sentence investigation report?
We have, Your Honor.
Is it substantially correct?
Your Honor, over on social history,
At what page, you know?
his mother's address is actually 140 Walker Drive in Smithville, Tennessee.
Yes.
And he is now living
What
on,
page is that on?
they're not numbered, it's just social history where it says family.
All right, go ahead.
We'll fix it, Judge.
I talked to Carson about it, and he is actually living now at 6 Blankenship Street in Jamestown, Russell County. So that sort of simplifies our entire procedure, I think. If he's want to be there for the foreseeable future.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Plead guilty of wanton endangerment, finish receive a sentence of 5 years. I'm plead guilty of criminal mischief, you receive a sentence of 5 years. However, the 2 5-year sentences should run concurrently for a total of 5 years. Probated for 5 years, supervised. Defendant should pay restitution, $1,000, 5% clerk's fee. What are the court costs? $150. You need some have him pay that?
He will, Your Honor.
Yes. Okay, can you pay $50 a month? Yes. Okay, $50 a month, first payment, maybe 30 days from today, you need to be in the probation parole officer.
It should be taken there.
Christopher Young. Commonwealth versus Christopher Young, 25 CR 00118. Are you Christopher Young?
Yes, sir.
You here with purpose of arraignment. You born in 1995?
Yes, sir.
Last four digits, social security 1276.
Yeah.
You have a right to remain silent. You're represented by an attorney. Grand Jury Clinton County has returned an indictment charging you with receiving stolen property, being a persistent felony offender, possession of a handgun by a convicted felon. Being a persistent felony offender on that. Mr. Bailey, you acknowledge the identity of your client receiving that way from where you can name an interplea of not guilty.
Yes, Your Honor.
Senator, reciprocal discovery order here. Which will require the Commonwealth to present you with all the evidence. They have. What's the Commonwealth, the handgun thing? Tell me something about this.
I don't know Lanny or Clay know much about it, Your Honor. It's, Mr. Stockton and I have talked about it briefly. There are some issues about it.
I'm sure there are.
There are.
Yeah.
Substantial.
It's just an information on the Walmart that was located at a residence. Christopher Young.
So, all right.
He is, because judge last things, it's twice on.
Negotiation day on January 5th, next court date on January the 8th, 9 a.m. on both days. Mr. Young, I don't want you to say anything right now. But one of the things that I frown upon largely is convicted felons with handguns. So you need to make sure you stay the heck away from any handguns or other weapons or anything while you're out on bond, because if they come and find something on you, it will not be a good thing. Okay? You understand each other? Okay. And I'll go ahead, since I set the bond previously, and honor the bond. You need to. What are you standing up for?
I'm gonna speak to him when he walks out.
Good. Friendly guy. Okay, we'll see you then. Now let's go back. Okay, we have Erica Decker. You're unsure what you make?
Do what? I don't have no employment right now.
You wouldn't have what?
I don't have employment. Is that what you asked?
You're not sure. What the family can. Okay, I'll go ahead and point. It looks like you've got eligibility for some other programs that would indicate that. You're here for the purpose of arraignment, I guess. You need that. We'll give you that, it's earlier on there.
No.
You got copies in that? Yeah.
No, I'm not.
$73. Nope, thank you. 103. 103. Yeah, thank you, sir. You have a right to remain silent. We represent your attorney. The grand jury of Clinton County's returned an indictment charging possession of drug paraphernalia, possession of controlled substance, and methamphetamine, theft of lawful taking of possession, and possession of controlled substance. You acknowledge the identity of your client, receiving that in the way formal reading, arraignment, and pleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Schedule a negotiation day on January 5th, next court date on January 6th, to give you some permission to buy. You've got, I'm signing a reciprocal discovery order. You've got a kind of a whole garden full of different sort of charges here from different locations. So I would give you some advice. You need to kind of live at the foot of the cross. You got something's going on here, even if you aren't guilty of some of these exactly. There are too many different things that indicate to me that there's some other issue there. So you need to be very careful. Understand what I'm saying?
Yes, sir.
Okay, thank you very much. I guess we're at Kimberly Elmore now. Kimberly Elmore. Morning. Commonwealth versus Kimberly Elmore. I understand you wish to enter a plea, is that correct?
It is correct, Your Honor.
Is this a felony plea or?
It is.
It's 25 CR 0073.
Yes, sir.
Motion's been tendered, says you wish to enter a plea today. Is that correct?
Yes,
Are you currently under the influence of drugs or alcohol?
no, no,
Is
sir.
the plea freely and voluntarily given?
Yes,
Are you the same person named in the indictment that we just previously stated?
yes, sir.
Is your judgment impaired in any way today?
No, sir.
Can you discuss this matter with your attorney? And are you satisfied with his advice?
Yes,
The
sir.
evidence Commonwealth has against you, you believe you're fully informed about your case. You understand that you do not have to enter a guilty plea today. You understand that?
Yes,
You have certain rights under the Kentucky United States Constitution, where I can accept a plea guilt. I need to know that you're fully understand those rights. I'm gonna go over them, and at the end, I'm gonna ask you, you understand, okay?
okay.
Nick, you have a right not to testify against yourself. No one can make you say anything, right to speak, trial by jury, right to be represented by counsel, should your trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor, right to appeal this matter to higher court if you lose, right to require the Commonwealth to be beyond a reasonable doubt that you guilty charged against you. Understand that by entering a plea of guilty faith, you give up all those rights. You understand that?
Mhm.
I may consider Commonwealth's recommendation, but may apply a range of sentence, but I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait the pre-sentence investigation report and probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Mhm.
Okay, now what is the Commonwealth's recommendation? Excuse me.
Commonwealth of Kentucky agrees to dismiss possession of controlled substance, first degree, first offense, methamphetamine. Possession of controlled substance, first degree, first offense, unspecified. Possession of drug paraphernalia. Possession of controlled substance not in the original container. And upon a plea of guilty to trafficking in controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 7 years probated for 5 years supervised. The defendants are entering to complete a long-term inpatient treatment facility determined by and scheduled through probation and parole. The defendant shall be transported to the inpatient facility by probation and parole. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner with accordance with the laws of the Commonwealth and the holding agency.
So what you agreed to?
Yes,
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
yes,
Are you doing so of your own free will?
yes,
Knowing your constitutional rights to explain to the student your desire to proceed and allow the court to fix your punishment within the range permitted by law.
yes,
Okay, you understand that after any guilty to any future felony convictions, if you had a future felony conviction, can be enhanced towards the sentence. You understand that?
yes,
Okay, look at the signature on the line, right? That's your signature.
yes.
I order a pre-sentence investigation report to be done and we'll schedule sentencing on January 8th. I'll let you remain free on the same bond. You need to be a probation parole officer. Okay, did we ever find out about the Sean Stockton expungement? It's okay. It's automatic expungement. I don't know why. Okay, let's get a little sign that. Now, I guess we've got to go back to Clinton County Jail. You said doctor down there. Clinton County Jail. Clinton County Jail. Clinton County Jail, Clinton County Jail. Did somebody call? There we are. If you turn the microphone on. Thank you. Bring one back if you want to. Daniel Anderson.
Daniel Anderson.
Daniel Anderson. Are you Daniel Anderson? Good morning. Were you born in 1988? Last four digits, social security number 1882. We're here on 25 CR 00113 for arraignment and 25 CR 0055 for pretrial diversion. We'll do the arraignment first. You have a right to remain silent. Grand jury of Clinton County returned an indictment charging you with disposal other than permitted site of facility, receipt of stolen property, and theft of motor vehicle registration plate. You present that. Counselor, do you acknowledge the identity of your client received indictment? Waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order right now. It requires the Commonwealth to provide you with the evidence necessary to prepare your defense. We will schedule you a negotiation day for January 5th and the next court date for January 8th, and your attorney will be down. When you going to go see?
Tuesday.
He'll be down to see you and discuss this in detail, Mr. Anderson, on Tuesday, he said, okay? Thank you. Mitchell Comstock, sentencing. Are you Mitchell Comstock?
Yes, sir, Your Honor.
Yeah, and you were born in 1967, the last four digits social security number 8279. This is 25 CR 0013. As your client had an opportunity to look at the pre-sentence investigation.
Yes, sir.
Is it substantially correct?
Yes, Your Honor.
This was a jury trial held on November 17th, 2025. Fleeing and evading, the jury gave him 5 years, enhanced to 10 years. Terroristic threatening, second degree, 5 years, enhanced to 10 years. DUI one. Thank you. DUI one, $200 fine in 48 hours. Assault fourth, 12 months. Theft and lawful taking over 512 months. Criminal trespasses, 12 months, and wanton endangerment, second degree, 12 months. The jury recommended that the two 10-year sentences shall run consecutive to each other and concurrently with the misdemeanor for a total of 20 years. Now you have you have a right to appeal.
Yes, sir.
And so have you been down to talk to him about that?
Yes, and he,
So you have a certain limited number of days you're aware of that.
I am aware of.
Thank you very much. Jamie Harold. Jamie Harold. Yeah, Mr. Comstock, I'm waiving the court policy considering the legal consideration. The UIP is how much charge? $780.
So you say what?
The court policy.
625.
625, he should pay that, start paying days after his ultimate release, okay? Are you Jamie Harold?
Yes, sir.
Good morning, this is 24 CI 0081 and 25 CR 00111 for arraignment. You have a right to remain silent. The grand jury has indicted you for disregarding a stop sign, fleeing or evading police first, reckless driving, driving on suspended operator's license, failure to maintain insurance, possession of controlled substance, methamphetamine, possession of controlled substance, first offense. Possession of controlled substance, not an original container. And PFO on fleeing of a. Counsel, you acknowledge the identity of your client, received indictment, waive formal reading arraignment, enter plea not guilty, reserving all pre-trial motions.
Your Honor, we have a resolution in this case.
Enter the guilty plea.
Okay. Felony?
Yes.
Okay. A motion has been tendered, Mr. Harold says you wish to enter the plea today, is that correct?
Yes, sir. Yes, sir.
Okay, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified in 24 CR 0081 and now under 25 CR 00111?
Yes, sir.
Judgment impaired today in any way?
No, sir.
Discuss this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
Review the evidence the Commonwealth has against you. You believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, sir.
We'll go over them and then ask you if you understand.
And we have an information, we have paperwork for that.
Yeah, but he just, yes.
I believe it is.
I'm returning the information, and I don't know whether the term information indictment is correct or not. I just think it's information that will. Commonwealth charges on October 29, 2025 in Clinton County above named to commit offense of wanton endangerment first degree against the peace and dignity of the Commonwealth. Counselors, are you telling me present that you acknowledge the receipt of that information?
Yes, Your Honor.
So what you're telling me that this overall plea agreement takes care of that information also?
It does.
Okay. Are you satisfied with your attorney's advice?
Yes, sir.
You reviewed all the evidence, you believe you're fully informed about your case?
Yes, sir.
Okay, you have certain rights under Kentucky and the United States Constitution. You don't have to enter a guilty plea. You have the right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to part of the Commonwealth if you want a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea guilty, you have to give up all those rights. You understand that?
Yes, sir.
I consider Commonwealth's recommendation, but I may apply any range since provided by law. I don't have to accept the recommendation prior to accepting any recommendation. All the way to precinct's investigation, parole and probation, parole and event. I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence. You will have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes, sir.
Judge, what is your recommendation here?
Your Honor, the Commonwealth agrees to dismiss disregarding stop sign, fleeing or evading police first degree, reckless driving, driving on suspended operator's license, possession of controlled substance not in original container, possession of controlled substance first degree, second offense, persistent felony offender first degree. On plea of guilty to failure to maintain insurance on a motor vehicle as required by Chapter 304, the defendant shall pay a $500 fine and cost. Possession of controlled substance first degree methamphetamine second offense, the defendant. Sorry, Your Honor. Shall receive a sentence of 3 years. On a plea of guilty to information indictment, wanton endangerment first degree, the defendant shall receive a sentence of 5 years. The 3-year sentence and the 5-year sentences shall run consecutive for a total of 8 years. Serve 60 days in jail with the balance probated for 5 years supervised. This 8-year sentence shall run consecutive Secondly, with Clinton indictment number 24 CR 00081, the defendant shall enter and complete the Clinton Specialty Court. The defendant shall first serve the 60 days in jail, then be released from incarceration in the morning of the specialty court orientation. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above cases disposed of in a manner consistent with the laws of the Commonwealth and holding agencies.
Yes, correct, Your Honor.
Is that what you agreed to, Mr. Harrell?
Yes, sir.
You all accept the plea order pre-sentence investigation report begun by probation and parole. Let me show you, make sure this is your signature on here. There, Mr. Harrell, see that, is it your signature?
Yes, sir.
Orders and order your sentencing to happen on January the 8th, okay? Thank you very much. Mr. Robert Hurt.
Hurt. Hurt.
Commonwealth versus Robert Hurt.
Yes, sir.
Which is 25 CR 00116. Mr. Hurt, I see your affidavit here. You say you have, how long has it been since you had a job?
I'm self-employed. It's been probably,
You say you make $0 a month.
no, sir. No, sir. I make about $500-600 a month.
I'll go ahead and sign it. Okay, you have a right to remain silent. You have an attorney here. Did I sign? I don't know whether I have signed it or not. I was just amazed at that, so the grand jury of Clinton County has charged you with possession of drug paraphernalia, possession of methamphetamine, theft, unlawful taking or disposition. 4 counts. Persistent felony offender on various of the charges, on theft charges. Criminal mischief. PFO on the criminal mischief. PFO on the criminal mischief. PFO on another criminal mischief. In possession of burden. You acknowledge the identity of your prior received indictment, waive formal reading and arraignment, if please not guilty, reserving all pretrial motion.
Yes, sir.
Assign reciprocal discovery order, sir, that requires the Commonwealth to provide your attorney with information to help you prepare for defense. You can do a negotiation day on January the 3rd, no, 5th, January the 5th, and the next court date is January the 8th, okay?
Thank you.
Okay, sir.
Wendell Shelton.
Randall?
Wendell Shelton. Are you
Yeah.
Wendell Shelton?
Yes, sir.
25 CR 0093, Commonwealth of Kentucky. Are you born in 1978?
Yes,
That's 4 digit social security number 2766.
yes.
Hey, we're here on a pre-trial conference. What do we have here?
We need a negotiation date.
Negotiation date on January the 5th and export date on January the 8th. Your attorney will be back down. When are you gonna talk to him?
Tuesday.
On Tuesday, he'll come down and explain, get ready for the negotiation date, okay?
Okay.
Thank you very much. Justin Smith.
Justin?
Commonwealth versus Justin Smith. I'm gonna sign the authorization for your public advocate. Here for the purpose of arraignment, the right to remain silent in your attorney's presence. The grand jury of Clinton County has returned an indictment charging you with burglary in the second degree or complicity burglary, burglary in the third degree or complicity burglary, theft, unlawful taking disposition of a firearm, or complicity theft, unlawful taking. And theft, unlawful taking, disposition, or complicity of theft, taking or disposition in criminal mischief. Various counts. There are also PFOs involved. The indictment form is a little different. This one, PFO on possession and PFO on complicity for burglary second, PFO on complicity for burglary third, step of lawful taking a firearm, PFO on theft or unlawful taking disposition over 1,000, 7 counts. Okay. You acknowledge the identity of your client, received indictment, waive formal reading, or enter plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
And sign the reciprocal discovery order, sir, that will give your attorney and you the information necessary to prepare your defense. Negotiation day on the 5th, next court date is on the 8th, both of January at 9 a.m. Okay, your attorney will be back down there on Tuesday. Tuesday to talk to you. Finally, William Willis. Howell versus William Willis. Are you William Willis?
Sir.
Good morning. You're here on 24 CR 0014. 24 CR 0015 for pretrial diversion revocation. Were you born in 1997?
Yes, sir.
Last 4 digits social security number 1336.
Yes, sir.
What does the Commonwealth have to say?
I need to, Mr. Payne,
Your Honor, we've got a motion to continue. In file, yes, sir.
Based on what?
Based upon I was hired yesterday and there's an underlying charge. I've met Mr. Willis at the jail briefly, haven't even had an opportunity to look at what he's accused of now, other than just glancing at it.
You don't have any objection to that, do you?
no,
Okay, continue it to January the 8th. Your attorney will be at, when you going to be down to see?
It'll be next week. I'll come back down.
Okay, he'll come back down there.
I'll be down soon.
Okay,
Thanks.
is there anybody else there at the jail we hadn't talked to?
I think that's all, Your Honor.
Okay, thank you very much. Y'all be excused. Anybody else here on this docket? Anybody? That concludes. We'll have to be back in at 1 o'clock. 1 o'clock, in recess.
Mute it back. Mute it.
Wofford. When honoring the volleyball. Okay, the child support docket will start. Brewington versus Brewington. I get the brain trust.
Yeah, without them,
Brewington
I'd be
versus
lost.
Are you Mr. Brewington?
I am. Judge, in this case, it was a motion to modify the custodial parent had requested a modification. There's two children, ages 6 and 10. And so the current child support set at 60 a month per an agreed order that was filed in 12/19 of 23. And I think Mr. Brewington works at the 76 Falls Golf Course now, and based upon the minimum wage calculation set by the Kentucky Child Support Guidelines, it would be $312 per month. It's what
How much a month?
he's paying 60 a month right now for
60 a month.
60 a month. But apparently this is just a set. But now where she had asked for a modification, and Stephanie figured it using minimum wage, and it was $312 a month effective December 1st.
Okay, you have any objection to that? Okay, well, they're in order. Thank you for being here.
Thank you.
Cabinet versus Davidson.
Don't think anybody's here on that one, Judge. Judge, on this case, ordered to pay, Frankie Davidson's ordered to pay $312 a month and current 62 on arrears. The arrearage right now is $1,248 and asking $500 to be paid by January the 7th.
Okay, how many days you want to put?
60.
60 days.
30.
January 6th.
Oh, January 7th. Yeah, January 7th. My bad, Judge. Don't pay me any attention. So January 7th.
So we'll put 60 days in there.
Oh,
Yeah, 60 of the day. Yeah.
Okay, Ricky Farrell, Cabinet versus Ricky Farrell.
Ms. Pearl's here and I've had a conversation with her, Judge.
And I would probably say it's a great day to show that
I
tenacity.
wouldn't do that. I'd just leave it like that.
Certainly, I think it's more so under the leadership.
Ms. Pearl's agreed to have $700 paid by January the 7th. And we can, the order's probably already been submitted. We'll submit another order with the amount that she's agreed to in there. It's gonna be $700.
And if I could respond. I can do that.
All right. Good.
Okay. Kathy Graham versus Luke Foster.
This is a motion for default. Probably need to let Stephanie be sworn in.
Raise your right hand. You swear that the testimony you're about to give is the truth. Okay, yeah, what's your-
I do.
State your name.
Stephanie Wisdom,
By whom are you employed?
Clinton County Child Support,
What is your position?
caseworker.
Are you familiar with the case of Kathy Graham versus Brooke Foster?
Yes, I'm the caseworker.
Okay, and was a complaint filed for child support against Miss Foster,
Yes,
and was she served with it?
yes, October the 4th.
Have you received an answer or any response?
No,
How many children are involved in this case?
one child.
Okay, have you picked up an amount of child support based on the Kentucky Child Support Guidelines?
Yes, we're asking her to pay $216 per month,
Okay, and where are you asking that to begin?
December 1st.
Okay.
Okay. Submit the order. Gray versus Gray.
Judge, in this case, this is an arrearage only, in paying 50 a month.
Oh. Sorry. Yes.
Gray versus Gray.
This is Laura.
In this case, this is the custodial, the Barbara Gray, and that's Laura Gray. And
In this case, this is an arrearage only, being paying $50 a month on arrears. The arrearage amount now is $4,400.54. The last payment was August 6th of this year, and we're asking that $900 be paid by January the 7th.
Are you Laura?
Yes, sir.
What do you have to say about this?
Actually, the last payment was last week. I gave $100, online confirmation. I paid online. And I had a wreck in April and it literally almost killed me, you know?
Raise your right hand. Swear the testimony you're about to give us the truth.
Yes, sir.
Okay, you want to inquire or?
State your name.
Laura Gray.
And so are you currently employed?
I am still laid off work. They've reset my arm and my shoulder 4 times. And I lost my job because I was laid off work.
Where were you working at?
Huddle House in Audison,
And when did you have this accident?
April. And they have still been working on my arm and I had to have surgery on my coordinator as well. Because I flipped my escalator.
Okay.
Yes. What model Escalade?
It was a 2007. It was an older model.
That's
My
what
uncle
I'm
gave it
saying.
to me.
Do you know what amount you could pay or come up with at
I
this time?
spoke to Stephanie and she told me like we had an agreed thing. I can't remember the name. It was agreed something. And I can do like 500 by then. I can do that. I just can't do 900 because I literally have no money.
Now, this is, how old are the children? Why is this arrearage only?
How old are the children?
The child is no longer in her care. It's an arrearage only case. I don't think the child's emancipated, but no longer in your care, right, Ms. Barbara?
Yeah.
Okay.
Where is the child?
With his dad.
Which I still haven't got my visits. And he was-
It's not about visits, it's about money today. If you want to do some visits. Is the dad your son?
Yes,
Okay, and where is the dad live?
he lives in, Somerset.
Okay, now, do you have child support obligations to the dad?
No,
How old is the child?
he was born in 2014.
No, okay, let me,
11
Well,
years old.
11.
so nobody's paying child support now?
I've been paying arrearages up until April.
Do you have, is there any current child support? Why
There's
is
an
there?
obligation to my knowledge, unless it's not on our system.
Why?
I'm not sure, unless
He told me on a visit we seen, he let me see Dominique one time. And he said he was never gonna let me see him again.
I don't want to hear about
Well,
that.
it goes to the child support. He
We'll get to
said,
the child support.
he said he wasn't even going for child support against me, so I wouldn't see my son. And I have it on a recording.
I don't care about that. I told you this was not about.
That's why there's no current.
It's not about visitation.
I know, but I was just. saying.
It's not about visitation. How much did you say?
900 is what we were asking for January 7th.
And the arrearage is just what, 4,000?
$4,400.54.
And how much monthly is it supposed to be?
50.
Okay, I'm gonna split the difference, say 700. By then, and after that, wait a month, and you start making $60 a month. That should take care of it within a year, okay? I'm not going, you need to do that. You understand what I'm saying? You need to pay and get that over with. I don't really know what your deal is about visitation, but you've got a right to come in and ask for visitation. What county was the divorce in?
Wayne,
Well, you go in, they got a family court over there, I think. So you go, if you want to do something about visitation, that's the place to go, okay? Thank you very much.
thank you, sir.
Yeah.
Have a good day.
Coleman versus McNew.
Judge, in this case, it's an out of state that we've inherited, and we're asking Jeremy McNew to pay $1,000 on or before January the 8th.
What is an arrearage case?
It is
How
a
much is
rich
the
case.
arrearage?
It is $24,904.23.
Does he have employment or?
Never met him, never,
So he served to be here today?
yeah.
Okay. Submit to order.
That's it.
Let's go off the record. How are you,
This is Jumper. Jumper will jump. It's a 4-foot perimeter fence.
Step off.
Because even though that's 25,000 or so.
the Zoom, you got Zoom user on there. Would you identify yourself? Zoom user, identify yourself. If you're on the Zoom meeting for the court here. If not, we're going to disconnect you. You've got 10 seconds to identify yourself. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. We're out of here. We have an EPO that's here, Amanda Elizabeth Dalton. Amanda Elizabeth Dalton. Is she gonna serve?
More about the hands at work powering America.
Made loud.
Okay, the case was called, no one showed up. Have they been served? the record.
Exhibit H is Lincoln filed official investigation into 6 Democrats. For a trial out of this. There is already some digging going on, as you mentioned, Democrat Senator Slotkin claimed to be on the September mission trivia. Is as we report. Familiar with the incident, the 2 survivors climbed back onto the
But I don't want to ask you, can't, once you get something on there, you need to leave alone.
He told me at 25 I have to do the start video and unmute it.
Right, because good long, waiting more reaction.
I have my capital for us. Good to have you there, Bill. Thank you. John?
Do you think the same, do you think of? Well, Jackson. Yeah. Fight, United States is drug. Change of the deed. This is all about saving American citizens and protecting our national security. All right, so that's basically it's like an elevator pitch, what this is all about. Democrats say the Trump administration it's desperately trying to make this how they go. It's Al-Qaeda. About 31 Americans died at the hands of Al-Qaeda and ISIS. So last year in this country,
and you think they can hear you now in the courtroom, which is not a problem, but, you're so they'll undo that. Just stay logged in, but just, turn the
You want to take that one? People sitting in a cave, are not necessarily, it's crazy, you meant to say was should say they are citizens. Well, some of them didn't like the drone strikes either. All right, why don't you?
Ms. Alexa, will you you got your microphone on there? Okay, thank you.
It's done, no.
Okay, that's okay. Did you hear counsel say you wanted a bench trial? Do you prefer a bench trial or a jury trial?
My apologies, Your Honor. My audio just started from your courtroom, so I haven't heard anything.
You haven't missed anything, I assure you.
Okay.
Okay, what we go is counsel said if he wanted the bench trial on damages. The court, I think the appellate court sent it back down and said we ought to have a hearing on damages, correct?
Correct.
Is the appeal over? Here's Mr. Ramsey. Let's go off, stop right now. Mr. Ramsey? Yes, sir. Now we're back. They're back on again? Okay, get him back in. Hey, Greg. Okay. They're back on again. Okay, we already removed them and they're back on again. Okay? Do you have their phone number?
I don't. My secretary does, I'm sure.
Tell them to turn your, Bill and Michelle, Hodges, your attorney's back in here. You need to turn your camera on and your microphone. Turn your microphone. What's the deal with you people that you keep coming back online here? Your case is over. I told you to disconnect. What's the problem?
We never heard or saw anything.
Are you talking about on the Zoom meeting, Your Honor?
I'm talking about this hearing that we just had about your case.
We never heard or saw anything regarding the hearing. We've been waiting.
We were asked to turn on the video and we did that. Miss Megan asked us to turn on the video and then we got no video from you guys at any point other than just a minute ago.
It's over with now, and your attorney, there wasn't anything permanently done, but your attorney will tell you what the ruling was about visitation during Christmas. That's the only thing that we talked about. And we talked about going into mediation to get a professional mediator to deal with you and your daughter. That's the only thing that was decided. Now, your attorney's gonna call you in a few minutes. He says his secretary has your number, okay? He's gonna call you and discuss this with you. If y'all will disconnect. I accept the fact that I thought you were trying to be disrespectful by coming back on, but I accept what you say, okay?
Oh, yeah, no, sir, not at all.
Okay,
No.
okay, I accept what you say.
All right, sir.
So he will call you and explain it to you. I hope you all have a Merry Christmas, okay?
Thank you, sir. You as well.
Okay. Okay, now.
Thank you, Your Honor.
Yeah, thank you. Go ahead.
Judge, we believe that this case should be a bench trial. We believe that it would take at least at most a day for the court to hear the evidence and make a decision on damages.
Okay. Mrs. Lexell, how do you feel about it?
We don't disagree. We are still in the early stages of our damage discovery. We have noticed a corporate rep deposition for December 22nd, and we've also served some written discovery and are in the process of negotiating what we perceive as some deficiencies in that written discovery. So I can't estimate as we stand.
Tried to mediate. Have you tried to mediate?
We mediated before we went to the Court of Appeals and
no good. Okay.
no good.
Okay, you got your calendar with you? We're going to try this case on March the 3rd.
We'll be ready.
Okay?
Thank you, Your Honor.
You have any problems with discovery, there are a couple of rule days that come in and you can file a motion, or if you have something extraordinary, okay? Thank you very much.
Thank you,
Thank
Judge.
you.
March 3rd, 9 a.m.
9 a.m.
We'll be here.
I should hope so.
Okay, we can excuse your.
Sure, absolutely. Have a safe day. March 2nd. March 2nd. March 3rd. Okay. McCracken versus Lakeside Bulk Storage.
Good afternoon, Your Honor. Colin Bugner on behalf of Lakeside.
Can I read that?
Tell me what you
I think
want.
they renoticed that for January 8th.
This is your motion to amend your complaint.
Oh, my motion to amend is still on. I presume we would pass it. I'm sorry. Yes, okay. I need to amend to add the current owner of the real estate, Your Honor.
You have an objection there?
We would just ask that, an actual amended complaint be filed and a summons be filed so they could formally bring.
That sounds reasonable.
Sounds reasonable.
And Your Honor, I'd also just like to, ask that, we have a motion on, we renoticed it, for our client is will possibly bringing in, a excavating company. We've had an outstanding motion for partial summary judgment, I believe, for over a year. And if you rule in our favor, there will be no reason to bring them in. If you don't, we will have to bring.
How do you feel about that?
He is correct, Your Honor. That motion has been submitted for a long time.
Do you have any objection to it?
You're doggone right, and we filed a response, and I would be astonished if the court ruled in their favor based on case law and based on the facts. But I think it's something the court just needs to review and enter an order, and
Well, let's,
Share the sentiment that it would be astonishing if you didn't rule.
I'll surprise a lot of people. I'll surprise a lot of people. So you're gonna be, next month, you're gonna come back on your,
Possible.
yeah, on your motion. What is your Brad?
Your Honor, this is the case where Mr. McCracken deeded Mr. Rutchley a piece of property, reserved a written course and distance right away, and they basically moved it. Now they're basically saying they can move it. I think that's cutting the chase on it, but anyway. So what if the court review that?
While we're here, we might as well take a short refresher course on me. You refreshed me on what you're.
Your Honor, our motion is that, we have the right to modify the easement as long as it does not inconvenience them.
Now,
The easement,
wait, let's stop. Let's do it bite at a time, okay? You agree with that?
I do agree with that.
Okay,
And
okay. Now, it's your position, it does inconvenience.
now we're driving through an RV park to get to our property with a gate and all that. So yes, it is
What
a
about the gate?
impairment.
the RV park this isn't about an RV park. This is about,
He's talking about where he has to go to get to it with the new right of way that you can place.
there was no right of way there. It was a wooded, rocky hillside. There was the inconvenience is that we made it better for them to be able to get to their property. They had never used this property, and then in their affidavit, in the response, their clients gives this grand plan of building this development He hadn't done that in 13 years since that deed had been written. And if he wanted to put that in the deed with the easement, he could have. Mr. Cross is the one who drafted the.
Drafted it well, Mr. Becker. And Your Honor, Mr. McCracken is the general manager of an auto dealership in Madison, Tennessee. He is in the process of retiring. We set this easement up adjacent to another adjoining piece of property with anticipation that it might all be incorporated. Colin's correct. We had not used that as of yet, but it's now completely unsuitable for our intended purposes. It's
Your intended purpose stated in the document.
well, Your Honor, again, it's a surveyed right of way of a certain width.
Yeah.
And a certain location, and
And nobody's interfered with it. Nobody's blocked it at this point.
We've made a roadway. It was a wooded hillside.
I'm talking about a roadway up there eastman.
Your Honor, here's what happened, okay?
I'm asking, was,
They've gone in and they cut.
Let me ask you what I want to know, okay? As far as the roadway that they created didn't go up the easement that you had. They went up some other way, and you want the right to improve your easement.
Your Honor,
Because if you're not going to improve your easement, I really don't see why you want to keep the right of way up there if you're not going to improve the easement. If
Well,
there's another
Your
way.
Honor, what they've done, they cut it down about 12 feet. It's just it was here and now it's down there. You just about got to see it.
I'm sure I will get the opportunity at some juncture to see it. But I also don't want to tarry around with it long enough and interfere with the usage that they have of their property. If your client cannot improve the right of way that you have, that's the issue. It's either cannot or does not want to improve.
We
that right of way.
cannot, at this point in time, we cannot use the right of way we had. They were making us go through
Okay,
the
so now you can't use that. What do you want, damages for that?
Yes.
Okay. And what you're gonna say is the one that they created that interfered with your easement is not equal to the one or except.
We think we could establish what our damages are. It's a messy case because, no disrespect, but the.
So don't say anything disrespectful.
Well, it's not disrespectful to anybody but the guy that got to moving dirt before he was supposed to.
Well, what I want you to do is, I want y'all to, I guess, look, he's got a motion for summary judgment. It would be just as easy for me to have a quick bench trial on this thing and go out and look at the property, that sort of thing, and make a decision. And that way there wouldn't be an issue on whether or not summary was right or anything like that. So I'd ask y'all to get to your calendars.
But Your Honor, I want to remind you, they want to bring Harris Construction in because Harris was working for his client. And
There ain't
now,
nobody gonna come in until I do this bench trial. That's the reason I want to do it quickly. Okay, now, is there any other discovery anybody needs? There's the document there and there's the way the place looks, okay?
yeah, we have to we went down there, I took Paul Brown down there one day to look at it, couldn't get in because the gate was locked. I've got access now, but we're going to have to get some estimates on some things.
Well, you're the one that filed a complaint, right?
Correct.
Well, I mean, you don't know what your damages are there?
Well, I have professed to opposing counsel of what they are, and we're not.
Well,
we're
but
not
you don't have
agreeing
an
with it.
expert. Well, the problem is my friend Richie Sanders in the state Senate used to say, you've got the big eye. I want you to make your comment up. Okay, let's look at this. The rule day is January the 8th. By January the 8th, you should have all your discoveries served on them 10 days before January 8th. That way, if you want to file a motion, we'll come back on January the 8th and we will set a trial sometime in January.
Okay.
Does that sound fair to everybody?
You get ready.
Weather's bad now.
I'm fine.
Weather's bad now anyway, you know.
I got
It's hard to move a rocky hill in cold weather
Well, we'll all drive down there, weather permitting.
in your vehicle, hopefully.
I've got a good side to side, but Mr. Butler.
I got a 4-wheel drive truck.
I'd say you don't want to get it on that property. Okay.
Thank you, Your
Happy
Honor.
holiday. Moons versus moons. Okay. This is a motion to alter, amend, or vacate findings, and one of the grounds you said was a failure to appoint a guardian ad litem. Is that right?
No, Judge, I think in the way your order was written, it said that neither party requested a guardian ad litem. And that was just in my argument that basically the court also had the ability to appoint a guardian ad. We didn't request one, so I don't think that could be used as a basis as to why, or as one of the findings in the order, which was what you put in your order.
It was a recognition of the fact that neither party, it did not affect my opinion. Okay, so.
But the main basis is the fact that this child is 6 years old, and for the majority of his life, he was doing an equal time share. And then when this order was entered, there was a shift, but we don't have any findings showing that the child has been injured, either mentally, physically, or anything along those lines. So that's why I'm asking the court to reconsider, possibly amend on the ruling you made on the timeshare.
You have a response to that?
Well, I filed a brief response yesterday, Judge, but essentially the court knew that over the 18 hours of testimony that we had related to all this, had plenty of facts and evidence and cited in accordance with the statute, and your decision is probably, that was something that you knew and you considered that and you made a decision.
As far as this situation is concerned, I've seen this young lady around. I don't think I've ever had a conversation with her that I'm aware of, you know, even before this. I know your client. I know his family. I've held him in high regard, that sort of thing. But there comes a time when judges have to make decisions about aberrant behavior collectively on what they have. And I just saw too much in the record and otherwise to think that it would not impact. And it's a decision that I am not happy with. And I anguished over it. It took a lot of time. But there wasn't anything that makes me think that I was wrong or that I would change my mind. Maybe the Court of Appeals will do that. And if it does, I make decisions sometimes that I don't like. I don't like this. I don't like it. But I really think it's the right decision based upon all of it. And I know the parties, I mean, your client probably thinks he shouldn't have any visitation or shouldn't have been termination of parental rights. There have been termination of parental rights where the behavior of the parent, in my opinion, over the entire spectrum of things that are going on is such that they should not have a large amount of time. I think that people had their parental rights terminated for less than some of the things that have happened in this case, especially the fact that they cannot co-parent. You know, I mean, that's the worst part of it, that they can't co-parent. So if they can't co-parent, then you got to decide where the child would be best situated. And that's primarily what led me where I was going, is they're not capable of co-parenting, in my opinion. And maybe if there had been, a de facto custodial sort of situation, nobody qualified for that. Maybe somebody else ought to be raising the child. But
Can I state?
you need to step back and ask, you need to step back. You need to be quiet too, okay? Okay, can you be quiet, you think? Okay, thank you.
Judge, my client did ask if he could make a statement to the court about what he's seen in his child. And that's-
The proof is in, and this is to alter, amend, or vacate. Okay.
I've explained to him what
I
this
could very
motion
well
is.
be wrong. Okay, I don't think I am. And I've really had all of this case that I want. Okay, it's been knocked in the companion cases and the other situations, and it's just a tragedy. It's a tragedy because, I've seen a lot of good aspects of Mr. Moon's about caring for his children and everything, but the totality of the circumstances here and what I've seen in this situation makes me think it's right, and I don't like it, but I'm not going to change it, okay? Because what we need is some certainty in this case, and if I'm wrong, the Court of Appeals can tell me I'm wrong, and I'll do what they say. I'm not in doubt. I'm not always right, though. Might not be right this time, but I have no bad feelings toward anybody involved in the thing, and I didn't like it at all. And I'm sorry about some of the things that happened to Mr. Moons, you know, I'm sorry about that sort of thing because, you know, I've seen him, be brilliant as a coach and as a, you know, in a lot of different ways, but I'm not going to chance it. Okay.
Judge, while we're here, just for clarification, because there was an issue when the parties were following the order on holiday. My client did not get to see the child at all on Thanksgiving, and he was supposed to get the time after what she was designated per your order, page 18, subsection D.
That issue came up, we reviewed the order, there is nothing to indicate that she did anything improper.
Well, look,
You
on
gave-
Thanksgiving, what?
She was supposed to have the child till 3 o'clock Thanksgiving Day. Provision D says holiday time not scheduled above to the parent exercising timeshare and visitation should be with the other parent. She refused to let him have the child 3 o'clock Thanksgiving Day then to his weekend.
We interpret that differently, Judge.
Why would you want him to have
We're
a
good
child?
with that, if that's what you want to do.
Yeah, I
we're
want
good.
to do that. I don't want to take this child away from Mr. Moons and his family, you know, on the holidays and things. I don't want that to happen. And, you know, my mind can be changed at some juncture if everybody, including you, don't try to be a human being about making sure that this child gets to spend some Thanksgiving holiday with his extended family. It's important. So let's do a little makeup at Christmas, okay? Y'all agree, some kind of makeup at Christmas. Who has a child Christmas?
She does at Christmas as well, Judge.
Okay, and you have it all Christmas and Christmas Eve?
Judge, your order, as we read it, indicates that he gets Thanksgiving every other year and Christmas every other year. We looked through it to see if it was interpreted differently. Does it
Is that
indicate
correct, Ms. Moon?
that he doesn't get other time?
Okay, go ahead. What do you say?
Judge, under provision 2, the holidays, page 17, subsection I, it says Thanksgiving break beginning 6 p.m. The day school ends until 3 p.m. Thanksgiving Day. And then you've
So
got
let's
the
stop
other
it.
sentence.
Stop it.
We're good with that.
Okay.
We-
Why
it's
didn't that happen?
It's an interpretation of the.
It's not an
I don't see how you
interpretation.
can interpret that. I don't see how you can interpret it 3 p.m. on Thanksgiving.
Judge, the part that she's reading in says that she gets to keep the child the other times when she doesn't have a visit. But we're good with that. It's nothing that she did to try to frustrate or do anything different.
What does it say about Christmas?
Christmas, it says beginning at 6 p.m. The day school ends until noon on Christmas Day, the 25th. So therefore, our interpretation per the wording of the order would be he gets the child December the 25th until school starts. Because the way that sentence reads is not scheduled above to the parent exercising timeshare should be with the other parent. I don't know how that's an interpretation issue, Judge.
It is because she's the parent not exercising visitation, but cut to the chase, we're good with it.
Okay.
We're good with it.
Okay, they're good with it.
All right, I just want to make sure so that this doesn't become an issue every holiday.
Well, I want to make
Because,
sure,
you know-
nothing could make you happy not to be an issue with the holiday.
Can I speak so?
I don't think so.
I was just gonna tell you about Thanksgiving.
Well, we've already resolved that they conceded that in future Thanksgivings it'll happen. And I don't want, now we know what the interpretation is, and that's what's gonna happen here on out, or you'll be held in contempt. Okay? Okay, thank y'all very much. Okay. Owens versus the Medical Center of Clinton County.
Yeah, that's fine. Yeah, so.
Talbot versus unknown heirs of Shannon Murray. What do you got here?
Your Honor, it's simply my motion for approval of attorney's fee in the amount of 10% of the sale price as per the schedule, plus reimbursement of all the filing fees and service fees and such. So property didn't bring much. We actually, Mercers were somewhat compelling that they wanted to buy it, and they bought it reasonable, but I don't even know who ended up with it, but
Cousin Watt.
Yeah. But all that being said, I haven't talked to Holly about the division of the rest of the proceeds, but this just takes care of me.
$580.
Big fee.
That's the smallest fee I've ever seen you get for anything.
Well, no, you just didn't look close enough. The way it goes.
I think this is reasonable. I don't think it's something.
That's the schedule, and we'll collect a little off Miss Haddock's portion, but her portion
I
won't be
don't even
much.
know how much more money y'all.
Yeah. It's fine. That's all I had, Your Honor. If I may be excused.
It'll be fine. Thank you. Okay, anything else to come before? Come look at Gates. River Valley AG Credit versus Lisa Faye Brown. Is that what Mr. Hurt is here on?
Yes.
You leave? Ms. Wiggins, are you on this case?
I am judge for River Valley.
Well, I hope you've enjoyed Clinton Street.
I have, absolutely.
Yeah. Okay, what do we have here? River Valley Credit versus Lisa Faye Branham. Motion for summary judgment. Do you have a defense for that?
Yes, Judge, this plaintiff's motion for summary judgment, I filed a response raising an affirmative defense, filed an affidavit therewith.
The affirmative defense was?
My clients believe the contract, which in this case was essentially a fixed rate note, a security agreement, was unconscionable. That's the nature of the affirmative defense that we got. They demanded a jury trial in their initial answer. That's.
And Judge, I would say on that affirmative defense, that might be a conclusion that you are making, but you don't have any supportive evidence for that. You have not cited any.
I filed a not lengthy, but somewhat lengthy response to their motion for summary judgment, where I talked about case law, the conclusion of, as she put it, unconscionability is, as the case that I cited in my brief recognizes, it's highly fact intensive. I cited an affidavit. There's also a deposition of my client in there. She alleges that in Kentucky, take a step back, in Kentucky, unconscionability is bifurcated. There's two parts to it. There's procedural unconscionability, which is essentially the bargaining process, whether that was fair.
Is it underlying debt in this case? Is this a credit card or what's it?
Yeah, it's purchase of a tractor. This particular case is with the financing company. So procedural unfairness, unequal bargaining power, substantive is what the terms of the contract. I'm sorry.
They didn't have to buy the tractor.
That's certainly true.
They bought a tractor for somebody else. Right? What's your argument about that? How's it unconscionable?
With regard to the choice, which is, I think that's what the court's getting at. That's one of the things that the case law centers on, is whether or not they had a choice in this. The choice typically refers to, was it a take it or leave it style contract? In other words, did they have the reasonable opportunity, as the other party did, to interact with the contract, to make changes, to negotiate terms? This was a boilerplate contract.
Well, I mean, every time you go to a car dealership, it's like that, or a tractor dealership, or if you want to go down here and buy some furniture, they all have standard contracts. Is that your position, Ms. Wiggins?
It is. And also I didn't necessarily get that portion of your argument from your response to my motion. I interpreted your response to my motion to be that your client simply did not understand what she was reading, and that is also not a defense.
My client alleged in her affidavit that the contract was not explained to her, that she did not understand it, and the terms as expressed in the contract or as understood by the plaintiff were not as understood by my client, which isn't. I'm sorry.
Yeah, I'm sorry I interrupted you.
No, you're fine.
The thing about it is, so somebody that you cannot explain the contract to can never buy a tractor, because they say that they didn't understand the contract. She understood they had to pay for the tractor.
Yes, our argument would be that the disagreement over what its terms meant is itself an ambiguity, and an ambiguity can remove it from a legal decision to a factual decision. As I said, it can rest on that.
I'm just not gonna buy that.
I understand.
I'm not gonna buy that argument, it always bothers me, the kind of cases that bother me the most, except for cases involving children in custody, which we have to do. The cases that bother me most are when somebody repo a tractor or a car and then go out and sell it for the minimum amount and then get a deficiency judgment for all its interest, and then they come and collect it. That bothers me a lot. And then the other ones are these land sold for taxes, where somebody buys $150 tax bill and collects $4,000 off of somebody over 150, but that's what the law is. And I think that Mr. Hurry, if I were to buy your argument, and thank God that some circuit court judge can't make a rule that would apply all over the state, there wouldn't be any installment contracts or anything sold anywhere in Kentucky. Nobody could have any credit, and it would have a terrible effect upon the economic health of our state. So respectfully, I'm going to deny your motion. I'm going to enter summary judgment.
Thank you,
And
Judge.
now, after I've entered summary judgment, a word to the wise is sufficient. Bowling Green is not that far from here, and that's where people from Cumberland County have to go to file bankruptcy. So there's not much blood in this turnip. That's all I gotta say. It'd be good if you call Mr. Hurd and see what kind of blood you get out of the turnip, because you got a judgment, but I don't know how collectible it's gonna be. These people have they've had some hard times.
And I'll just add to that, Judge, I appreciate that comment. We're open to hearing any offer that they have. The only thing we've had so far since the inception of this is agreed judgment for the full amount. So in some sense, we're playing with house money because there's no reason to, that doesn't give us much to
Well, it would be
negotiate
reason
with.
to see how much they think they can squirrel out of it.
That's right.
If your client gets bankruptcy, but
Precisely.
that's outside of my province. That goes down to the big judges down in Bowling Green, the bankruptcy judges, and the federal judges, and all those other people who have lifetime appointments. Okay. Well, thank y'all for your patience with me.
Thank you, Judge.
It was by far not the worst case. Happy holidays.
You too.
Does that include the business of the Clinton Circuit Court? Now,